My lord, with the consent of the petitioners and my learned senior, my lord, I am mentioning item number 41. My lord, department is filing an affidavit, my lord, within a week. We are sending for vetting. It is about, my lord, ST certificate. So unless that affidavit comes in, my lord,
Was it 23 matter and the department has not filed the affidavit?
the thing is that if you are about
And you
75
say
for
that unless the department does not file, nothing can happen. We'll consider the department has no say.
we have sent it for vetting, my lord. We have already sent it for vetting.
So you have sent it for vetting, we file it. We'll take it up today itself. Don't come up with this thing. Excuse me. And don't mention about filing of an affidavit at the motion at the mentioning hours. Mentioning is for you have difficulties during the time. Means it's difficult on your part to appear at the time when the matter is called, it's a different thing. But otherwise, if you want to any adjournment on a filing of an affidavit in reply or affidavit in opposition, this is to be taken at the time when the matter is called. Not now.
The lordship will heard the matter, my lord, we want to dismiss them.
Which
So
one?
Once you can come to your lordship.
I hear all the matters. So don't worry. We'll see when the matter is called.
And my absent maybe. I may be absent, my lord, because I'm going out.
So you want an adjournment?
If it takes one, otherwise I want to, I had come to mention it for upgrading it.
You want to upgrade it?
Yes.
Okay, we'll upgrade it. Anyway, this is also motion. If he's here, we'll take it up at the.
Petitioner is not here, but I have.
Because
taken
the-
note of it.
I have for.
Because there's, I think he disposed of something,
You are the response number?
7 and 8 and 14.
They are the beneficiary of that, my lord.
Rival group, my
Oh,
lord.
we'll pick up the matter when the matter reaches. Let's see what happens.
Item number 48, an additional affidavit has been filed on behalf of the Project Fund authorities. That will be called for lordship.
You want to bring it on record? Yes.
Beg with your lordship. Lordship, I beg to mention item number 14 of daily, 14 lordship.
1-4.
One for lordship.
Yes.
That Dighali Singarajan mean Samobai Samiti Limited, lordship. The matter becomes infractual. The settlement period was 1314 to 1920, lordship, but NIT was called for lordship. Matter becomes infractuous, lordship.
Mr. S.K. Sarkar, the council appearing on behalf of the petitioner submits that the petition has become infractuous in view of the fact that the settlement period is over. Taking into account the above, the instant petition stands closed as infractious. Interim orders, if any, stand vacated.
I think item number 21, man. It's better maybe taken after next week, man.
Hmm?
21, man.
Hmm.
And this matter may be adjourned for the day, man.
Why?
My lord, in this case, the petitioner filed this petition for non-consideration of the representation, my lord, for claiming for fair price show and a license. But in the meantime, during pendency, my lord, the fair price show license is granted to another person's, my lord. My lord, we have challenged that license, my lord, and that petition is listed with the report number 4, my lord. Item number 15, my lord.
Fantastic. So let it be there, but this has become infractuous then. Why do you need so many repetitions? You filed a representation for the purpose of considering your application. On the other hand, it has been given to somebody else. So you have challenged that. So under such circumstances, how does this thing remain infractious? Mr. East SK. The legal counsel appearing on behalf of the petitioner submits that the instant petition was filed for non-consideration of the representation of the petitioner for grant of a fair price shop. He submits that during the pendency of the petition, the fair price shop has been already awarded to some other person. And in that regard, another petition has been filed challenging the said award. He therefore submits that the instant petition has become infractious, and accordingly, the infractious Taking into account the above, the instant requisition stands closed.
Item 28 of today's list.
Hmm.
28. Sorry, petitioner mother died some days before, so we need some present status. of
Whose
the
mother died?
Petitioner's mother.
How is it relevant?
Some instruction regarding the status of the, this termination of the RO lordship. We have to find one, reply of the affidavit lordship.
We'll see that when the matter comes. Don't come up with this an adjournment for filing reply.
May please, I mention item number 51. This matter has become infected. Order.
Your name?
Examine.
Mr. DJ Mehdi, the learned counselor. Here your first item, Mr. Period is over.
Lordship, can I just look at matter? Can I just look at it?
Admits that the repetition has become infructuous in view of the floating of a fresh NIT. Taking into account the above, the instant repetition stands closed as infructuous. Interim orders, if any, stands vacated.
Please, lordship. Lordship, I beg to clarify. Item number 11, 12, and 13 with consent of the other side. Lordship, my senior is out of station in Delhi for admission of the attack. So matter will
What?
be adjourned.
11 to?
11 to 13. Lordship.
I'm for respond.
What is this matter?
Matter pertaining to the settlement of the fishery. Your Lord.
These matters needs to be immediately finished off. Fishery. Take it up.
Lordship,
These are
my
2020 matters.
Lordship, my senior is out of station.
So what? Who is your senior? Where is his name?
Item number 13. Your Lord.
We'll see 1 and 11 and 12. Come up with all this. See when the matter reaches.
Lordship, I also pray for this.
Mr. Counsel will see when the matter reaches whether Mr. JL Bhuya's presence is at all required or not.
Lordship, item number 5 also I made a mention of, therefore mention your lordship.
What is this? 2016 matter. Absolutely no. Next.
You may kindly allow me to do item number 2, lordship.
Item number? Mr. Your name?
Arbora.
Mr. Arbora, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant repetitions. Accordingly, the repetition stands closed on withdrawal. Interim orders, if any, stands vacated.
Wait, Sister Lordship, I'd like to mention with regard to item number 18, Lordship. The brief has been withdrawn from us, Lordship, by the petitioner. And since the petitioner has not engaged any other counsel, so we need to take instruction whether we can appear or not.
You appear. You cannot withdraw like this. You appear. We'll see when the matter reaches.
Obliged. Yes, Lordship, as per instruction given by learned counsel, Mr. S. Dutta, Lordship, I'd like to mention item number 29. Lordship, he is out of station.
20?
29, Lordship. Both Ibora and Mr. S. Dutta is out of station, Lordship. I dust.
Oh, this matter.
Yes.
Devashish Lahiri. Okay. Not before me.
Obliged.
Isn't that the Indranil Lahiri's brother? Not behind.
Item number 64, lordship, you have received an affidavit in opposition, lordship, on 4th. We require 2 weeks time to file our reply to that.
Oh, Mr. Counsel, did you come just now? I've been very clear and don't mention about affidavit and reply. And if you don't have the time, we'll record it that the council doesn't have the time. Confess.
Item number 1, order no step.
There is better is to the settlement of various soaps under the municipality Mongol. There was a market and while allotting the soaps under the new constructed building, lots of anomalies were there. Now they filed the affidavit that they are going to cancel the entire selection process.
And revisit
And
them.
they will
We are going to revisit the matter.
Conduct
and
it
revisit
afresh.
that fresh selection will be made in para 3 of the affidavit we have stated.
Very good. You have stated that.
Yes, para 3 and the resolution also I have an next. Page 36, madam. Affidavit started from page 34, madam. No, so I have annexed the present, the usual. Allotment of seat in fish market. There are three, my.
Heard Mr. B. Gugoi, the learning council.
Yeah, point was, one more. There was an order of this honorable court. We have approached earlier, page 31B, the 31B, annexure F. There, my lord, honorable court has already laid down that, my lord, while conducting the selection, the board will at prior hand, my lord, fix the criteria how it will be selected. Because earlier they call for interview. They are fish vendors, my lord. For interview, they will give, my lord, that is how they will be selection will be conducted. They will, my lord, ascertain that first. They will lay down
Where?
page, my lord, 31B. It is, my lord, WPC 5186 of 2016. Order dated 23/9/2000.
What did you say? In
Lord,
view of
it
the
is the
above
last second
apprehension, the petitioner have been arraigned for the time and I do not find it appropriate to continue to entertain and accordingly dispose of leaving liberty to so and so.
The last second paragraph, my lord. The last second paragraph. On specific instructions, whoever has submitted as a decision has been taken to adopt guidelines and criteria.
We have also submitted that certainly. Presently, there is no plan on the part of getting dismantled and all. I mean, relevant. Now they have already made the fish market. How will they do? Then otherwise you don't want to have private briefs. I'm asking you.
So, my lord, at least.
No, why should you,
laid out
why
the
should you
criteria.
today? Why should I today say that they are going to follow? It is deemed that they will follow. Are you not a state, Mr. Mahanto? Are you not a state? Within the meaning of Article 12, it is deemed that they are going to follow. Unless being a counsel always for the respondent, you have presupposed that the state is not going to follow. I hope you don't think so. Mr. B. Gugoi, the learned counsel appearing on behalf of the petitioner. Petitioners, Mr.
Page 25 was the earlier advertisement.
Yes, who appears for the municipal administration? Mr. M. Borman appears on behalf of the respondent number 1. Mr. T.J. Mohanto appears on behalf of 1 and 4. Mr. T.J. Mohanto, the senior counsel assisted by Ms. P. Bhattacharjee, appears on behalf of the respondent number 2 and 3. The petitioners herein are aggrieved by the select list issued by the respondent number 2, whereby the petitioners have been excluded from the allotment of the fish stalls in the newly constructed fish market. It is seen that pursuant to the filing of the writ petition and issuance of notice recently, the respondent number 2 in its meeting held on 21/5/2024 at 3 p.m. had taken up a resolution for the purpose of cancelling the allotment of seats to the fish vendors made in the year 2017 for the newly constructed fish market situated in Dhon Bazar, and have decided to make allotment of seats afresh. This aspect of the matter has been brought to the notice of this court by filing an affidavit by the chairman of the respondent number 2, who's taking into account the said stand so made to the effect that the respondent number 2 and 3 have already resolved to cancel the earlier allotment and to go for a fresh settlement by following the due process, the learned counsel appearing on behalf of the petitioner submits that the petitioner does not have any further issue in the instant proceedings. Accordingly, the instant writ petition stands disposed of, thereby, on the basis of the statements so made by the respondent number 2 and 3 through the affidavit filed by the respondent number 3 before this court, and
Only thing, there should be a proper notice, so that everybody can.
why should I say that? Are you already said? They have only resolved to cancel, they have not yet cancelled. So therefore, I put it that I am disposing it in view of their stand, but I kept it there.
Item 3, order implement.
What is this?
I am for the petition number 5. And therefore, my senior, my lord, who engaged me. There is some agreement petition has been filed against that, my lord, we file reply also. Because my lord,
Hey, repetition on some.
and they were. Come on, put it on.
Who is the writ petitioner? Okay, what is your case?
Very
No,
sorry,
we
my
take
lord,
it
my-
that none appears on behalf of the petitioner and
Right,
dismiss
right.
it.
person who engaged me, my lord, he himself, my lord. Okay.
No, Mr.
sorry, ma'am.
Mohanta, you are a senior counsel. So
Well,
if
I am
you are
part of
not
my
being
duty.
engaged, you are not being held by a junior counsel or assisting counsel will construe the none has appeared on behalf of the petition. Isn't that correct? Rule.
Actually, my lord, I am regarding the final hearing, my lord, I am not prepared today, but
I'm
anyway,
also
at
not
the
prepared
space.
for the final hearing.
No,
I'm
madam.
asking you, what is your case?
But this is not by the GMDA for demolition of the there is some portion of the, my lord, that building.
Where?
So that is annexer 6, page 27.
I am Molloy Bora, you direct the plaintiffs of a monastery to demolish unit the following unauthorized within 5 days from the date of the law. I'm feeling the MDA will agree to proceed with the demolition of the wall blocking the access to the stair to the ground floor demolition. Yes,
So that has been selling before this.
why this has been done?
My lord. My lord, they have.
Why this has been done?
This is done, my lord, they have already answered in my lord, page 21, my lord. Sorry, even page 22. Replied, my lord. I have given a reply, my lord, prior to issuing notice, my lord, but that was not been considered when properly. That's why before this honorable court and there is stay order, my lord.
And who is this person who wants it?
He's one of the, my lord, probably he's one of the head owner, my lord.
Who is being affected by the access to the upper floors being blocked?
My lord. No.
You know?
No, that is not correct. That is not the correct position.
No, whether it is a fact or correct position, we'll consider.
No, my lord, that is from commercial, first floor is commercial. Already there is a, my lord, other flat owner has no objection, my lord. That is already, there is a access there, 2 other rooms, but there.
You have gone over those other flat owners, we are not
My lord,
concerned.
commercial side only, my lord, that is blocked.
No, but the question is whether his access has been blocked.
No, his access is not blocked.
Yes.
Southman basement is there, my lord.
Who are you?
I am one of the flat owners, my lord.
Yes.
I have, my lord, come up before this court for imprisonment. Because, my lord, my access to the building has been blocked, my lord. And, my lord, now what he has done, he wants me to go to the basement, my lord, where there are no stairs to go to the basement. And thereafter, they take a lift to go to the upper floors. Whereas, my lord, the agreement as well as the
Is it
deed-
on the basis of your complaint this has happened? You have
Because I have
submitted
been
a complaint
My lord, yes.
to the GMC, GMDA,
GMPM.
and it is under such circumstances this has happened.
Yes.
Yes, GMDA, where is it? I am asking you whether it is on the basis of the complaint by them you have initiated actions. A simple question. Whether at the behest of him, Mr. G. Chaudhary's client, did GMDA take any action? See? The sad part, even after the passage of 5 years, the GMDA is not aware.
That they
to
have
do?
stated in the affidavit which has been filed by the GMPM, madam.
What is it?
But no complaint has been issued by us.
Station has blocked the entry and exit to the ground floor in the unauthorized the placement of imam. Is there any violation?
Yes, yes, ma'am, there is. And that is the categorical.
What is that?
My lord, your lordship can see, that can be, my lord, regularized, my lord, because what happened, it is a, first floor is commercial side. So, my lord, there is a unnecessary, my lord, public will enter in that, my lord, the commercial, that in residential area. That's why in that side has been blocked. There is other two routes are there, my lord.
No, my lord. this is
No, my lord,
not
now
correct
your
statement,
lordship kindly see, my lord, his interest, my lord. So if he has given a complaint, that complaint has to be, my lord, subject to me, my lord. It was not been supplied to me, my lord. I do not
If
know. my lord.
we first let him be a party, let him file an affidavit. So are you admitting that he should be made a party?
My lord,
You want his complaint, have a complaint.
yes, my lord, then,
Let him file an affidavit.
my lord,
So we include him.
my lord.
The instant application has been filed by the applicant seeking impleadment to the accompanying writ petition, primarily on the ground that the applicant has been affected by the purported illegal construction being carried out, whereby the applicant's access to the first floor have been blocked. It has also been submitted that the applicant has also complained to the GMDA for the purpose of complaint to the GMDA as regards the purported illegal construction beyond the approved plan by the petitioner. So taking into account the above, it therefore transpired that the applicant is a necessary is a necessary party to the instant proceedings. Accordingly, this court impledes the applicant herein as the respondent number four to the accompanying writ petition. I stands disposed. Main writ petition. Mr. G. Chaudhary, the learned counsel, appearing on behalf of the newly impleaded respondent number 4, submits that he has already obtained a copy of the writ petition, and as such, he may be permitted to bring his stand by way of filing an affidavit. List this matter again on 9th of December. In the meantime, the affidavit be filed by the respondent number 4, newly impleaded respondent number 4, by 2nd of December. Petitioner would be at liberty to file the reply. Thereafter,
Interim order pass.
interim order passed earlier shall continue till the next date.
For admission item 4.
So you've got your file. You've got your file. What is your case?
the petitioner's family, my lord. They have been settled with land, my lord, forest land, in terms of pursuant to the, my lord, official communication. And annexure A, my lord, page 17, my lord. Page 17, official communication dated 21/7/1953. So since then, they have been enjoying the possession of the land, my lord, after getting the allotment, but the possession certificate was not issued to them. So they made several representations that was not considered. So, my lord, the petitioner had appealed this honorable court, and this honorable court passed an order, my lord, where a direction was given. Your lordship may kindly see.
Consider your application.
Yes, my lord, and to issue my lord, land occupation certificate, my lord.
Very
Your
good.
lordship may kindly see, produce the order of this honorable court, relevant portion, my lord. Relevant portion at page 42, my lord.
To consider the case of the bill for issuance. No,
Yes,
not
my
to
lord.
issue. To consider the case for issuance.
My lord, subsequently they have considered, my lord, and the Jamabandi was
Have
corrected.
they issued?
Jamabandi was corrected.
They issued.
No, my lord, but
Now,
Jamabandi was
because of the
corrected.
non-issuance, you are before this court.
My lord, no, my lord, this time for correction of the, we have challenged the corrected Jamabandi, my lord. Before issuing land occupation certificate, Jamabandi was corrected, my lord. So, my lord, your lordship may kindly see the last page, my lord. The correction was made where, my lord, instead of, my lord, 24 bighas of land, it is shown as.
So after
22
45
bighas.
days, what has happened after that?
Uh,
Then you.
Jamabandi
45,
was corrected,
45,
page 44.
The name of your original allotee has been given.
Yes, my lord. My lord, they started
20
the
bighas.
processing, and my lord, Jamabandi was corrected, my lord. Your
Then?
lordship may kindly see page 44.
Then what happened?
In the quantity of land, my lord. It is shown as 22 bighas, but actually, the land is 24 bighas, my lord.
You have been given 24 bighas of forest land.
Yes, my lord.
My goodness. What is wrong with the forest department? Have they become so benevolent?
But this is not that Jamabandi comparable to the revenue
Absolutely no.
one. This is, lordship, a record of the habitants of the revenue village who are allowed to settle there pursuant to verification by the DFO, lordship. And that can be changed anytime because it is within the reserve forest and they cannot have.
If it is in the reserve forest, isn't it now required under the ST and other Forest Dwellers Act?
For forest dweller, lordship, there is a different verification process by
No, isn't
that.
it to be taken into account by the Gram Sabha? Whether it is not required that they have to be there for 75 years. All these things factors are not there, or it doesn't apply only for the petitioners.
For petition, it doesn't apply, lordship,
Why?
because here the petitioner has not made any contention about being a forest traditional forest dweller. The
So
petitioner,
then how a person is allowed to remain in the forest?
because for forest villages, lordship, certain settlements are granted to people so that they can help in forestry works in the reserve forest, lordship.
Okay.
And
So these settlements are granted by whom?
DFO, lord.
So the DFO becomes the DC.
In for that area, yes.
Because I think there is a provision now, some forest regulation.
Yes.
There is a provision to the effect that the DFO becomes the DC for the purpose of settlement.
Right.
So he has given the settlement.
Yes, but these settlements are not permanent because they are all linked to whether they're providing services to the forest department or not. If, for example,
Is it to the forest department or to the forest?
to the forest through the department.
Let us see what is the provision. I also need to be enlightened. Some forest regulation. Now the concern her is you should have given for 24,
20.
not 22. One person you are giving 24 and you are throwing out other people. Yes, tell me.
35 families, my lord.
So what?
All have been allotted, my lord.
This is village forest.
Period for
Where is the settlement? Settlement provisions? I
My
saw
lord,
some.
I have
books
shown the
somewhere.
provisions that para 7, my lord, page 8, my lord. I have explained the provisions there.
Page.
Page 8, para 7. Assam Forest Regulation 1891 amended was enacted by the government for the purpose of regulating the forests throughout the state of Assam.
Where are rules?
There's a set of rules, lot by not have the hard copy, but there's a set of rules called rules for establishment and control of forest villages.
Where?
I can lordship send an email
No. How do you? If it is a forest or a forest village, is there an exception to section 2 of the Forest Conservation Act?
the way it is interpreted is that lot because it is serving the forest itself.
No,
It is-
therefore,
Yes.
in view of the 2006 Act, wouldn't it override
It would,
as regards the settlements?
because lordship, it can be considered as a forest purpose because they are engaged in forestry works. For example, lordship, maintenance of a road within the forest. So all those things are done by people who reside in that forest village.
Where is the provision? Show me that.
I have just emailed that rule.
For the benefit of any village community or group of village community and may in all manner vary. So if 29 says that you create village for the benefit of the village community, then how do you say about that they have to work for a forest department?
That is what the rules.
No, rules are made under these. But you kindly see 29 of the forest regulation. At the disposal, ALC may by another constitute any land at the disposal of the government, a village forest for the benefit of the village community or group of village communities, and may in all like manner vary or cancel any such. Every such owner shall specify the limits. Then settlement is where? The forest reserve trees in unsettled tracts. All claims to any rights other than the rights of village community for the benefit of such village forest is constituted shall be inquired into, recorded and provided for in the manner in chapter 2. Chapters 2 says Another thing. Yes, 21. No right of any description shall be acquired in or over a reserved forest except by succession or under the grant or contract in writing made by or with the previous sanction of the state government or some person on whom such right or power to create such right has been notified, vested, when the notification under section 17 was published. Yes, this I've looked into, this I've seen it, forest villages may be established within the limits of any reserve forest. Forest village are designed for the purpose, the boundary is authorized to evict summarily from the forest village without payment. Allotment of a month to include homestead or body will be first be made for its possible to which will be added insurance. But no household shall occupy more than 35. A household containing 3 workers, including the household builder. These are all forest villagers.
That is, Lordship, pursuant to section 74 of the Assam Forest Regulation Act. Lordship. In section 74, it says that people who have certain kind of rights in forest, they are bound to assist the forest department in certain situations. So hence, Lordship,
Where? Section?
74, Lordship.
This is different. This is a duty which have been imposed on them.
And
That has nothing to do that they have to work.
And Lordship, 72, section 72 talks about framing rules. Through that, these rules are framed.
But these rules were made then. But how do you take care of the Forest Conservation Act? Creation of a right in a forest.
That, Lordship,
In view of the recent interpretation of the Supreme Court in the as regard the term forest, it has been expanded. How do you take care of section 2, Roman 2B, I suppose, huh? Forest Conservation Act.
that could be, Lordship, reconciled by that very fact that these are not permanent right and they are
How can
subject
you
to
say these are not to be permanent right? These are settlements being given under 17. They have permanent rights out there. You can't evict them. But how are you treating now, after the 1980 Act? Unless you take care of the ST, and the ST and other forest dwellers. How are you creating it?
That I'll have to.
Because that is the problem. You can't create now. You have done recently. What has been done, court may pass an order, it's a different thing. That is for consideration. But these have been done only in 2014. In 2014, if you are giving, can you do so? Anything which is now in conflict with the permanent section 2 of the, because tell you see, even no, there can be no creation of rights.
Yes.
See the Forest Conservation Act. Except with the permission of the central government. Notwithstanding anything contained in any other law for the time being in force in a state, no state government or other authority shall make, except with the prior approval of the central government, may order directing that any forest land or portion thereof may be used for non-forest, that any forest land or any portion thereof may be assigned by way of lease or otherwise to any private person or to other authority, corporation, or yeah, by the government, that any forest land or any portion thereof may be cleared of trees which may be so and so. For the purpose of this section, non-forest area so and so. So under such how do you take care of that? Number 3, forest land.
Lordship here, from my understanding, the purpose was always to do forestry works within the reserve forest. But yes, Lordship.
Therefore, you have to go to that 2006. After the coming into effect of the 2006, which say that estates dwelling in the forest, no period mentioned, and other forest dwellers means those who have been there for the 3 generations, meaning 75 years. How do you take care of that being the basis? Because if you see the definition under the ST Act, forest includes various aspects, including these also. So isn't now the central act, which is there? You are a forest council, that is why I'm trying to enlighten myself. If it is the forest, the central act now takes care of that. And more particularly in view of the Forest Conservation Act, which starts with a non-obstinate clause, that irrespective of any law made by the state, then also you are to take the permission from the central government. How do you take care of that situation? Isn't that the language?
Because Lordship, in the older act regarding formation of forest villages in section 28, that has not been also overridden.
What overridden? I only see the definition of section, see the Forest Conservation Act. Why you are going into the older act? You see, 1970s, by the 42nd or 44th Amendment, earlier forest was only with the state government. It was brought within the concurrent list only in the 44th Amendment. And on the basis thereof, they have come up with the 1980 Act. Okay. Now kindly see, therefore, section 2. Notwithstanding anything contained in any law for the time being in force in a state. So after the coming into effect of the concurrent list, the central now takes the power. That all acts of the state takes a backseat.
Yes, and Lordship, that is the thing that needs to be seen, whether forest village as a concept contravenes this section 2 of the new conservation.
It's not contravening. That has to take a backseat in view of section 2. In fact, there is another judgment which I was going through that day. There were many villages in a place in Maharashtra. These very villagers who were there in the forest area. The government wanted to give these people pattas and all these things. The Supreme Court categorically says, yes, you can do so. It is necessary, you want to do it, do so. But in doing so, but this was just prior to the 2006. You have to take the consent of this, the central government. And that is how there was a direction that, okay, you take a consent. This was a area of around 1300 acres or something. That had to be given. You want to give it, give it. But you have to do it by that. Now, thereafter comes the 2006. Now, 2006 goes for the question of Gram Sabha and all the aspects are being brought in, where it is being done, creation of rights. Now, the creation of rights is only upon ST, forest dwelling tribes, as well as those who are other forest dwellers. 75. If that is so, how do you take care of now granting settlements?
For that, Lordship, an opinion will have to be sought because the concept of forests will, whether it will stand the test of this. That
Because now it has lost its edifice because of this section 2. Yes, it may be there for those existing prior to 1980. Therefore, I tell you, on 1990, the Ministry of Environment and Forest issued 6 circulars, of which those circulars, many circulars were pertaining to saying that prior to 1980, whatever rights were there, look into that. After 1990, don't touch it. How therefore can there be a creation of fresh rights by the state in respect to those without taking into account that first, without taking central government's thing, and without central government also can be done but on the view of the STNs forest dwellers.
But otherwise, specifically for this petition.
I think the petitioners should withdraw the petition
Exactly, Lordship.
and don't go into this bigger question for these 2 biggers and then lose the entire 22.
My lord, I filed this petition in the year 2016, my lord.
Madam,
After that,
2016?
my lord, I have lost control, lost contact with the petitioner. my lord.
Fantastic.
Maybe by now
I
they
think
have.
better, madam, the question is you need to withdraw. Because if we go into the deeper question, this settlement which has been made is wrong, absolutely wrong. It can't be governed. I think the judgment is of 1990, 94, 95. 97, 94, the judgment of the Supreme Court. 97, 98, that judgment categorically says you cannot give it to anybody. They cannot be. Therefore, what settlement now is being given to the forest has to be in concurrence with the central government. And if you don't do it here, you may go to the state or central government say that these are villages. Otherwise, therefore, you have the SC and other forest dwellers.
Those conditions are fulfilled.
Then I may be allowed to withdraw, my lord.
Better. Because at the end of the time, if again this matter comes and he comes up with some instruction, he'll cancel everything. Be happy with it. Yes. So and so the learned counsel appearing on behalf of the petitioner submits that the petitioner would not like to further proceed with the instant petition. Taking into account the above, the petition stands closed. Mr. I. Botaku has appears for the forest department and has no objection.
Applied.
But Mr. Botaku, think about it. Some other matter I'll catch hold of you again. How do you take care of this?
Forest.
Item 5,
Yes.
Guys, give space for accommodation for this matter.
Oh, this one. What do you want?
My senior is also.
Forget about your senior.
Out of
I don't
reason.
grant any area. Your.
I
whether you
prepared
could be
also
in
because
one-
of my
one-
demersion,
one
my
and
uncle
two
lost
years,
it yesterday.
You are here, but I could please. Then after that. Then what happened? Why are you before this court?
Lordship, because of the not taking action of the,
No, they have issued a notice. You filed a reply. Thereafter, what happened?
no action has been taken by the respondent for demolition of the illegal construction carried out by respondent of 50.
Somebody has constructed.
So 5
Then no action has been taken.
taken.
He undersigned any member. Oh. Proprietor Hotel Chanakya. Only notice was issued. And thereafter nothing happened.
Nothing happened.
Yes.
They have lordship, they have also approached before the on a learned civil court. Seeking injunction from the, in respect of the building. The learned court below has granted injunction in respect of the 5th floor, not to the 6th and 7th floor, because there is no any document for construction of the building.
Yes, why the commissioner is not taking any action pursuant.
109. 109.
109.
Before the learned civil judge number 1 also. There one application has been filed by the defendants defendant number 1, 2, 3, and 4, that is GMC law. Here lots of one statement has been made that the file relating to that building lordship, plot of land and building has got displaced or misplaced lordship. And according an FIR has been filed lodged on 10/5/2023. Paragraph 3.
The instant petition is pending, which in case is pending before or at the stage of production of original documents. Of mentioned defendant beg to state. Who are the defendants? Yes. That on demand, this honorable court had directed you to produce the original building permission file number in month before this court as per the order. The file bearing could not be produced before this honorable court as the said file is untraceable despite intense coincidence. Accordingly, a file was filed. So, how does
For lordship will say, and liberty was granted to the defendants to issue secondary evidence. Now, in this petition, lordship will find a copy of the titles of lordship at page 94. Lordship will see in the body of the petition, all the annexures has been there, were there. But in this petition, those annexures are not there. So at least if those annexures I find lordship in this petition, lordship, I can at least furnish it to the authority and construct that.
which annexure?
Kindly see page 94.
94 is the amended claim.
Lordship comes to page 101. 101. Lordship will find here mention of a notice issued by the GMC authority dated 30/12/2017. But
Okay.
these annexures are not,
Who is the plaintiff?
plaintiff is a private respondent,
They are the plaintiff.
but he has annexed this petition.
No.
No.
How is this
Title
relevant?
suit, the title suit was filed by them,
So,
but this is their petition. They could have annexed the annexures also.
no, whether they have given, this is not what they do, Mr. Nayak, is here they only filed the amended claim.
Yeah.
For bringing on record these documents, they have to, if they want to bring some fresh document, they have to take the leave on order 7/14,
Yes.
which they have to take.
But-
Merely mentioning of that, this is only an amended claim.
Yeah, but-
How does this have any relevance?
But I'm simply lordship trying to submit lordship. If along with this petition, annexers annex along with this title suit, if furnished to me lordship, then at least I will have some documents lordship to communicate with the department.
Are these documents not yours?
Or this
These are
title
your
suit there.
documents.
One notice dated 30/12/2017. That was the notice issued by the GMC authority.
Understood. So these are all your documents.
They have that also.
But Mr. Nayak, are these not your documents?
Yes, but that is why I first of all, in the first instance, if I produce that application at page 109.
So you say in 109 you file a petition that look here, due to fire, we have lost that file. And as such, the court has given you the leave to that effect. What is the leave which is being granted out here? And the record diverted that on air, this court directed to produce the demand so and so, and the defendant informed the court that aforesaid file is missing. In the backdrop of the defendant, the plaintiff clearly adduced secondary evidence. So you will produce the secondary evidence in the trial court.
And then JMC done.
Understood. But how does this have any relevance as regards you further proceeding?
Instruction because the file is misplaced.
The entire file is misplaced or anything to that effect? Then why you, if it is so, only see,
That-
you
that-
have,
That
you,
application at 109 will state.
no, you are saying that this is a notice which was issued to you by you on 26/6/2015, Annexure 2 to the petition.
And then the 30/12/2017.
You have issued thereafter 2, 3 notices. Now, after issuance of these notices, what has outcome? Means the entire file has gone lost.
This application was in the year 2023 and the FIR was filed on 10/5/2023.
So are we to understand that if the GMC loses the file for initiation of proceedings under 337, thereafter, even if there is an illegal building, the building can't be done anything by the GMC.
That has not submitted.
No, we are to understand that
At least for, because in this affidavit, another application is there for additional floors also. Initially, the building was there, they purchased the building along with the plot. One building was already there, ground plus, first plus, second was there, permission was there. Subsequently, they filed an application for additional floor. What is the outcome of that application? That is, I will not.
so is the GMC satisfied with their building? The simple question is this.
So far as this affidavit is concerned, GMC authority went to the site, they inspected the site, and they said nothing illegal has been constructed.
So
At least
as per the GMC, there is nothing illegal.
that is not the instruction from the GMC authority, but it is their affidavit. Proceed.
No, I'm not on there. I'm asking about the GMC. As per GMC, whether there is any violation. Simple question is this.
Not- For that, we have to go to the record.
Are we concerned saying that from 2016, you seem to be not aware, the GMC is not aware? As regards whether there is a violation or not,
Because that
it is
application,
not for this court to decide whether there is a violation or not, but the question is the GMC for the last 10 years doesn't know that there is a violation or not. And you have issued the notice without considering whether there is a violation or not. Are we to consider that the commissioner have issued this notice under 337 without taking into consideration as to whether there is a violation?
one case, Lordship may kindly see at page 91. 91 of the affidavit.
Yes.
Lordship, this a penalty was imposed, Lordship, for compounding the compoundable deviations.
So if it is a penalty imposed for compounding the deviation, so you had the file or something for how do you compound?
Was also
Understood, but how do you compound it?
was found.
Or is it that you compound, he comes out and pays that amount, then you compound it? Or is it the
As-
case
as
that you
reported
compound on the
from
basis of some materials?
Lordship file was misplaced in between Lordship and the FIR was of 2023. It's already compounded.
And Mr. Muket, you don't have the original? The permission?
I have any explaining in fact first look at it.
Very. Huh?
Because I had bought it along with the structure value, T plus two.
Where is your permission? Page number? Of? There's no page number 8 business nowadays. Page number 8, where is it? Where?
Annex A.
Affidavit filed when?
March.
There's no permission. You don't have a permission.
9/9.
So if he doesn't have a permission, then why the GMC is not doing anything? Where is the permission? Mr. Mukit, where is the permission? I'm asking you a simple question. Where is the permission?
Permission annexed in having in the name of one Rangalal Jain, who was the original owner of the land.
Where?
It was up to Z+2. Not beyond that. What you will find there is an affidavit we have received on 21st of April 2017. Affidavit they have filed.
Your application proposed 13/9/1999.
39/1999. In the name of one Rangalal Jain.
Rangalal Jain,
He was
Hansraj
the
Jain.
original owner of the land. Not
Then-
the name of the responsible.
What is the permission?
It was up to
see that C lot.
ground floor, first floor and second floor.
Ground, first and second.
Second. And this land and the building was sold without constructing the second floor. In terms of the sale deed,
Let
annexed
us
by the
take the sale deed.
sale deed, your lordship will find page next, because it's page number 10. And the 11th para will find your lordship at page number 13. Page number 13. Constructed the application status there and got the ground and first floor access.
Pertaining to holding number 49 and 49A of ward number 23 and 23A. Now let us see 49 and 49A. 49A also see third story.
First.
What?
Ground floor. First floor and second.
The 49A is third story.
Three-story. And
Third story will be ground, first and second.
so far the demolition part, they are saying that that has been compound.
And now how big is the building?
7.
What?
And lordship will see the so far the compounding part, it is in respect of 4th floor. They have demolished. For his compound, the penalty was paid. And so far the injunction granted by the learned court below, in respect of 6th and 7th floor, no injunction was granted. Lordship will find the case. Lordship in the second affidavit files, lordship.
Where is the GMC's affidavit?
GMC has not filed any affidavit.
Oh,
Lordship will find page number 89, your lordship. Page 89 of the second affidavit filed by respondent.
page
89. Considering from all angles, this code is the prohibited interim order dated so is required to be made absolute. Hence, interim order dated demand is made absolutely disposable.
Are you saying about the affidavit of 23rd of September 2024? Huh? First of all, you have to get these details correct.
Further, no injunction is granted in respect of 6 and 7. Page 89. your honor.
Mr. Mukit, did you obtain any further permission?
My vendor.
I'm asking you, after that, did you obtain any? So you had only ground plus first plus two.
3, 4 and 5. my vendors had applied for it. Some reminders were also given. That's why we,
So you are going as per the deemed permission.
so exemption was, structure was protected with fifth floor. 6 and 7, no exemption was. Thereafter, my lord, we made an appeal to the JDC for regularization. Some penalties imposed, my lord, that we have paid. And some thin structures were there. We have removed that as indicated by them. And we are waiting for the suit is.
You are waiting for round plus 7. GMC is guaranteeing.
My lord, they have not issued yet.
How much is the area of your building?
My lord, with 1 kattha, 2 liters.
1 kata 2 lesser. So it is how much and what is the square feet of your building?
48. Thereafter, 180.
You were sold 1 kata 2 lechas. That is complete share of 60 lechas of influencer in the land and photo in the area in the RCC house of Hansraj Jain. Lechas and photo house in RCC and Jain. So 1 kata 2 lechas would be 2,000, 3,000, how much? 3,200, 100 square feet. What is the permissible FAR?
That point of time.
Now I am asking, what is the permissible FAR? Are you are a GMD council? What do you know as per the bylaws? What is the permissible FAR?
Area wise, it depends upon the.
Where is this area?
Weight law.
Area is where? So it's a commercial building. So what is the permissible FAR you do as per your area wise building? We'll take it about 2, find it out. Not how you GMC does it. Absolutely no, Mr. Nayak, this is absolutely, this is not what we expect from the GMC to do. This is not heard of. That you, then in that case, why is the GMC at all doing any act? There are many cases where without a building permission you are, or you are saying that they don't have a building permission here. There are many cases where people, some persons just have made, I found in many cases where they have made an Assam type house in a land area. You say there is no building permission, we will break it. But here is a case where he did not have a building permission. He had only ground plus 2, and now he has a ground plus 7 without a building permission. You permit it without even taking it. And now you take a rules out here that how do I do it? I have lost my file. But is it permissible as per the building bylaws? Does it take you 8 years to know from the authority?
The file is not there.
Okay, we'll have it tomorrow. Ask the Commissioner GMC to be present in the video conference. Does it take for him there? Please the matter tomorrow at 2 p.m., 10:30 a.m. on which date the Commissioner GMC shall be present through the video conferencing link to be provided by Mr. P. Nayak. No, Mr. Nayak. One has to be very clear on this. Then you take a decision that let the GMC take a decision that in no cases we are going to go for demolition. You cannot come up here and have a pick and choose with anybody. How can a person having no building permission construct from G plus 7? It takes 8 years, and you have the audacity to make a submission before this court that the petitioner have not enclosed some documents, which are documents belonging to yours. We'll hear the GMC.
Plus 2 was already.
We'll see the GMC mail. No, nothing. Tomorrow at 10:30.
Item 6 to 9,
And so the learned counsel appearing on behalf of the petitioner, Mr. So-and-so appears on behalf of the GMDA. Mr. Jed Mukit appears for the respondent number 5. This is a case wherein the petitioners have approached this court filing a writ petition complaining as regards the as regards the inaction on the part of the GMC authority in taking steps in accordance with the provisions of the Guwahati Municipal Corporation Act 1971, as well as the GMC bylaws, as well as the building bylaws. So from the facts narrated and the materials placed on record, it is seen that though the writ petition was filed in the year 2016, but till date, the GMC have not cared to file any affidavit. On the other hand, it also appeared that the respondent number 5 was initially sold a building, a plot of land at measuring 1 bigha, 1 katha, 2 lechas, along with a ground plus 2 building, a ground plus 3 building, a G plus 2 building, which was and such permission were G plus 2 building, which was assessed to the GMC holding numbers 49 and 49A. Full stop. It is apparent from the materials on record that the respondent number 5 thereupon carried out certain construction whereby had made the building G plus 7. Admittedly, there was no permission taken prior to making the additional construction. The council appearing on the behalf of the GMC had submitted that on account of lack of instructions, he has not brought on record the stand of the GMC. Taking into account that the matter has been pending for the last 8 years, and there has been no affidavit filed, and the stand as submitted by the GMC to the council being not clear, this court is of the opinion that the commissioner GMC, who is the authority under Article Section 337 of the GMC Act 1971, is required to be heard. Accordingly, this court directs this matter to be taken up tomorrow at 10:30 a.m. when the Commissioner GMC shall appear in person through the video conferencing link to be provided by Mr. P. Naik, the standing counsel of the GMC. I am not. Any order, go and file an appeal before the division bench. No, nothing will. Oh. I'm asking him not to be here by person, video link. He can have it with his mobile. Don't come up with these excuses.
Case your lordship. The whole matter, lordship.
Mr. Counsel, you have no case.
That's your lordship, but at least lordship, the opportunity of hearing should ought to have been given to me, your lordship, as per the judgments, your lordship. Lordship, I totally agree, lordship, rule, respect the,
These are visual and if
section.
it is you admit that this is a visual and what an opportunity in view of the Jakwal Singh as well as Rule 95.
Lordship, but there are other two judgments of what this honorable court, lordship. Lordship in 1983 2 GLR 258, your lordship, where it says, categorically stated the lordship may I find permitted to read the paragraph. In our opinion, before an authority takes a summary eviction proceeding, it must consider whether there exists any bona fide claim of right of the processor.
Mr. Counsel, we have taken those aspects in Salahuddin's judgment. The question, all these judgments have been duly considered. But the question is here, that can there be any, you have any right to stay on a land which is a VGR land? Whether the governor gives or anything,
Lord,
that's a
that I
different thing.
Totally agree. But at least the
Nothing we-
opportunity of hearing ought to have been given to me, your lordship.
What
because I
opportunity?
invested
You are being heard out here. You want to withdraw and submit a representation, go there.
For 20 years, I have been investing my money there, lordship. This is my livelihood. Lordship. At least some opportunity of hearing.
No, there's no opportunity for VGR land. You knew it. Rule 95 was clear. Do you have the,
Lordship, that aspect, lordship, the concept, the aspect of compensation may also come, lordship. if
Absolutely
any
no.
opportunity is
there's no compensation which comes. There's no compensation.
in that case, in my
We
presence of
dismiss with cost, giving the state the compensation for not being able to use the land for 20 years. How much did you want?
lordship, actually, there was an interim order, your lordship.
Huh?
There was an interim order.
Interim order, I've
Very good,
vetoed it.
Lordship, in my presence, lordship, whatever order may pass, lordship may pass in presence of my senior. your lordship.
I asked the senior, he also stayed on the last day when the matter came up and therefore I fixed it today. He only said that just before the vacation, don't throw us out. That is the reason. And now when the matter is here, you say that my senior is not
Lordship
here.
will come, like, he will come just sometime maybe given, lordship. Actually, he is in court number 1 in a PIL matter, your lordship.
Fantastic. Let him be there. From here, he takes the appeal out there, carry the appeal out there to the division bench. Let him be there. Mr. Counsel, I don't consider here about the senior. The convenience of senior is not material.
In item number 6, my friend is appearing, your lordship.
That day, my matter was heard when your senior was
Yes,
present.
lord. I was there, lord.
I told them that you don't have a
Without
case in view of Jakpal Singh. I said that.
Yes.
It's recorded, be that as it may, it is apparent that the respondent also have taken action taking into account that the land in question is VGR land and in view of the judgment of the Supreme Court in the case of Jakpal Singh versus so-and-so. Let this matter be again
Yes,
listed on 611 then. No case.
The presence of his senior, the order will be also. Just after.
In the presence of your senior, there will be cost. Okay, 2 o'clock.
Lordship,
2 o'clock will be cost
lordship, that would be, lordship, that.
for
that will be a
taking,
pressure
for
on
not
the
being
petition.
permitting the state to use the land for the last 7 years by filing a refutation. We should impose cost.
Lordship, actually, on prima facie, lordship.
The law was very clear in the year 1996. You did not point out Jakpal Singh at that point when the matter was moved. You should have pointed it out. You were fortunate enough the counsel appearing for the respondent did not point out then. But the fact that in 2017 all the law was very clear, you could not have any right over the VGR land.
Lordship, but
Matter is over. There's nothing out
by
there. Rule
adopting a
18,
policy, lordship, the land was given to me for 3 years, your lordship. By adopting a policy, through a due procedure, my land was allotted to me. That is not
but
disputed.
can there be an allotment?
There cannot be a right title interest, your lordship, that I.
Forget about the right title interest. If you have no right title interest, you cannot stay there. You have a bona fide claim of right will be only in respect to those who have some semblance of right. There might be a case. If you see the penultimate paragraph of Salakuddin, yes, there might be a case. Yes,
That I am not holding, your lordship.
you are not holding it. That is your loss. And you knew it. You were assisting Mr. Chaudhary on that day.
Or if I'm
You
not-
knew it, that about this aspect I
regarding
categorically
Jakpal, I know,
mentioned.
lordship.
And you don't hold it, then we record it. That the council is not aware of a judgment of a division bench where the Rule 18 question came up. And which is a very sad state of affairs. Are we to expect, Mr. Counsel, that you are not aware of the recent judgments of the court? Are we to expect that? I always thought that you were a bright upcoming lawyer and you don't know about the judgment. And you have the judgment of 1986. In paragraph number 49 of that judgment, it has been categorically mentioned to that effect clearly that the division bench in that judgment of 86 could not have thought that it would have application as regards the VGR lands or all these lands. It is only in respect to wastelands where any person may have some right, a bona fide claim of rights.
But I,
Yes.
what I was trying to project lordship that I have a bona fide claim over this land. lordship.
Show me.
That's- yeah.
Show me.
Lordship, I invested, I invested money there, lordship, to establish a industry. Yes, lordship, that is not disputed, that means like the state can always evict me, but at least a operational hearing I was asking for, lordship.
Hearing for what?
Uh,
Why didn't you submit a representation then, there?
Lordship, before.
And come up before this court, then no opportunity of hearing was given. When you admit that this is a VGR land, you denied it,
It's not disputed.
then if it is the case that yes, this land was de-reserved, then obviously you may have a bona fide claim of right to it. Otherwise, no.
In my past,
7 years, 7 lakhs
lordship,
per year. You are doing industry,
Lordship, that instruction actually. I'm
some
not in contact with the
compensation
clients
should go.
also, you know.
like in forest, the Supreme Court said about the afforestation cost. You imposed on costs on here. You are deriving yeah, you didn't pay a single penny also to the government. The government is not entitled to any amount. 7 lakhs per year.
They are not in contact with the client with lordship. Actually, I'm not, though I'm assisting with such lordship, I'm not in the record of the case here, lordship. So I'm not.
Who is in record? The man appears on behalf of the petitioner on call, dismissed for default.
I actually was paying for a bit of pending, your lordship, can be,
I said about 2.
but lordship has said that it cost.
Absolutely. That I told him, ask your senior to withdraw these matters, then I may consider something. Otherwise, nothing. Otherwise, no cost. Afforestation cost, we put some cost in
In
it.
that case, lordship, we'll withdraw the.
2 o'clock.
Item 10,
Lord, in this case, the arbitral award is put to challenge by way of repetition by the state. Lord.
Oh, yes, we dismiss it.
The audited side, it's, side or at an amicable process.
No, my Lord, in fact,
Whatever are proceedings going on,
no, my Lord, we have informed by, we have filed after the last order passed by lordship, by clarifying that there is no interim order. We have filed a application for the executive court under order 21 rule 1-2, intimating the court that partial payment has been made. And thereafter, the executive court has passed an order directing to them to make the further payment. That the order is already there. So, my Lord, it's the matter ultimately before the executing court, my Lord, that's to be.
you are the respondent.
I'm the read petitioner, my Lord. I'm the respondent.
That is what I'm saying.
I ought to be
When
there,
Mr.
but that-
P. Roy started appearing
I,
for the
I'm
state
sorry,
of.
my Lord, I have to be in that side. Fact, my Lord, the order 58 order is filed. And FP provision, appeal also, right? Read petition also, my Lord.
But what I have placed to your lordship, we had asked the respondents where you consent to this. And they have replied saying, yes, we have received the payment, the entire payment. Then
No, not really.
lordship, we have asked them if you consent to this or not, and this is their reply. Lordship. After this, lordship, if they are pressing for more payment, it is
No, that if they are paying for more payment, let the executive court decide. They have already gone for the
that
execution.
is because we filed our petition is against the execution, lordship. That is the thing. So to end this,
Then how is this reputation maintainable?
because we filed it against lordship the Micro Industries Facilitation Council of Punjab. Because they did not have the jurisdiction to decide this case. And when they had come up,
Understood, but that is an award.
yes, Lord.
If it's an award under the within the meaning of Arbitration and Conciliation Act, then obviously you have to file 34.
But because Lord, it was without jurisdiction,
So
we went to this
without jurisdiction also, can you challenge it in a writ?
because
Isn't that the mandate of this thing, section 34? if it comes within the ambit of 34, well, you see, it's the Arbitration and Conciliation Act 34. It doesn't say so. And why should this court at all interfere with this impugn award, execution case, money execution 6?
But, Lordship, we had, we,
Tertiary, we issue to whom? Tell me.
to the facilitation council, Lordship.
No, we issue the tertiary prayer B to whom? Whom should we issue the tertiary? Tell me.
That will be against the order of the facilitation council.
My execution proceedings. Against whom should we issue a tertiary?
That execution proceeding, Lordship, has been started here, which also should not have been done because
To whom
that
should we issue the tertiary?
the facilitation council in Punjab, Lordship, that is the agency.
So you give up the prayer in B and C.
So that
And why have you paid the money?
because
Why have you paid the money?
a settlement process was started between both the sides, and to end this matter once and for all, Lordship, that is why it was started.
So you admit that this amount is payable.
Subject to that settlement, Lordship,
Whatever may be, go there before the executing court. Say all, make all your submission. It is just across the street. Go there. We are not here to look into this challenging of awards out here. You challenge the award of 2014 in 2017. Eh? How is it possible? Are these not arbitration awards?
then our Lordship, liberty may be given to us to approach the executing court to show this.
You can always do so. Why should I give you a liberty? He is prosecuting, you have a right of defense. Don't you have?
That can,
What to do? Dismiss.
will withdraw the report.
The learned counsel appearing on behalf of the state of Assam submits that no, don't withdraw. I dismiss it. There's a reason why I dismiss it. Because if you withdraw it, it may have a repercussion on you. You don't withdraw this. We dismiss. The instant petition, I heard Mr. I. Bhattakur, the learned counsel, appearing on behalf of the petitioner, and Mr. P.K. Roy, the learned senior counsel, assisted by Mr. S.K. Chakraborty, appearing on behalf of the respondent number. Respondent number 2. To stop. The present petition has been filed challenging an award passed by the respondent number 1 in terms with the provisions of the micro, what is that? And it comes within the ambit. Show me this. I can't do. Challenging the award dated 10/3/2014 passed by the respondent number 1 in terms with section 18 of the Micro, Small and Medium Enterprise Development Act 2006. And further challenging the seeking, setting aside and quashing of the execution proceedings, being money execution case number 6 of 2016, pending before the court of the additional district judge number 1 Kamrup Metro, along with the orders passed in the said proceedings. First, this court have duly taken note of section 18 of the said Act of 2006. I want to say that Act of 2006, wherein it is stipulated that an award to be passed is to be passed in accordance with the provisions of the Arbitration and Conciliation Act 1996. In other words, the challenge to the said award, therefore, has to be made within the four corners of section 34 of the said Act of 1996. This court have also taken due note of that in terms with section 34(3) of the Act of 1996, the period of limitation for challenging an award is the maximum period for challenging an award is 120 days, as has been well settled by the various judgments of the Supreme Court. Taking into account the said aspect of the matter, the filing of the instant writ petition to challenge the said award dated 10/3/2014, that too in the year 2017, not only is contrary to the provisions of section 34, but also amounts to circumventing the said provision, more particularly section 34(3) of the Act of 1996. Accordingly, this court is of the opinion that a challenge to the award dated 10/3/2014 passed by the respondent number 1 cannot be sustained in the present position. Now coming to the order, the registration, now coming to the execution proceedings being numbered as money execution case number 6 of 2016, which is pending before the learned additional district judge number 1 Kamrup Metro. It is seen that an award so passed in terms with the provisions of the Act of 1996 would be deemed to be a decree in terms with section 36 of the Act of 1996. Considering the same award can be put to execution. Under such circumstances, there is no jurisdictional error in the initiation of the proceedings for execution, being money execution case number 6 of 2016. And further, it is also well settled that proceedings pending before the civil court cannot be challenged or entertained by way of proceedings pending before the civil court, as well as the orders passed therein, cannot be put to challenge in a proceedings under Article 226 of the Constitution, taking into account the settled proposition of law as held by the Supreme Court in the case of Radheshyam. What's that? Radheshyam? Justice, it's Radheshyam, what is that? Versus so and so. I'll give it to them. Radheshyam. Huh? That's the Justice Goyal's judgment, Adarsh Goyal's judgment. Huh? 2015. Addition is. You give the citation, Mr. Chakraborty. Under such circumstances, the instant writ petition is devoid of merits and accordingly dismissed. Be that as it may, it has also been brought to the notice of this court that in the meantime, the execution proceedings have proceeded and there has been certain payments being made by the petitioner to the payments have been made to the petitioner. In pursuance to the award dated 10/3/2014, isn't it? As would be seen from the instructions so placed by Mr. Aibor Thakur during the course of the hearing. The same instructions are kept on record and marked with the letter X. This court, however, observes that the dismissal of the instant writ petition shall not preclude the writ petitioner herein, who is the judgment debtor in those execution proceedings, to take such pleas as permissible and good. Because if I withdraw it now, it may have repercussions on you, not on state of affairs.
Item 11, 13.
For these matters. Yes, what case you have?
I am for the third highest bidder. My case basically twofold. One, first of all, we had earlier approached this on the court. A comparative statement was not prepared. Therefore, there was a direction to prepare the comparative statement. Now, the comparative statement that is the next lot in the FA in opposition, that bears no date. So it appears to be an afterthought and it was prepared afterwards. Secondly, Miller, so far as the petition, the respondent who has been given the settlement, that respondent did not have the board existing board at that point of time. The board was set aside. Now, my lord, that at that point of time, this tender was submitted, my lord, without an authority. That is our case, my lord. And thereafter, my lord, other things, my lord, are that there was no proper verification of, my lord, the neighborhood aspect, which was not done. In fact, my learned friend's case is that in their case, no verification was done at all. In fact, there is a subsequent order which I challenged in the subsequent writ petition. In that order, there was a decision to take,
One tender,
one thing.
3 writ petitions.
My lord.
Now, how many tenders were there?
5.
And you were the third.
I'm the third.
Who is number 1?
Number 1, my lord.
But he didn't have the neighborhood certificate. Isn't it? And in view of the division bench judgment taking into account B.K. Srivastava, judgment, the Supreme Division bench has said that the provisions of which are there in the notification number 18, dated 18/8/2000, yeah, whereby the additional chief secretary has put these are the various conditions which are required to be proved. So irrespective of whether it is there in the NIT or not, this is the requirement.
Right.
That's the division bench judgment. And his senior wanted to get some time for getting other judgments to them. But this is the latest. We are bound to follow. How do you take care of that?
So far the neighborhood is concerned. There is children carried out.
Who is number one?
And
You are number one without a neighborhood certificate. But that was not a term in the NIT.
so far the neighborhood network has been verified by your field verification. We have not been included in that field verification. Only two in respect of second and third highest bidder, that field verification was done.
And it was given to whom?
Second.
And how do you come into the picture?
But I challenge because when I say Malad, that petition number 2 is also not petition number he's also not in the neighborhood. That's what I say. Malad.
He is not neighborhood.
That is what I contend.
He is also not in the
Malad,
neighborhood.
I say Malad, his board was not there. The person when submitted the tender, he was not authorized to submit the tender. Number one. Number two, Malad, there was no comparative statement because I had approached this honorable court earlier. A comparative statement was not prepared. So there was a direction to prepare a comparative statement, Malad, before Malad issuing the process. Now, what I find, Malad, is that the comparative statement which has been annexed, Malad, in the position, that bears no date. So it appears to be an afterthought, Malad, that this was prepared.
Obviously, this must have been prepared subsequently.
So, Malad, after the Malad, perhaps it's after Malad the settlement, Malad. So before settlement, it ought to be Malad prepared, Malad.
No, you can very well verify those documents. Actually, the records, whether it speaks to that.
That the records will reveal, Malad.
That's all.
And so far as the other part is concerned, Malad, I say, Malad, the person Malad, from the respondent number 2, Malad, sorry, the private
Because the
respondent,
problem arises if the court did not pass an order for preparation, it would have been different.
Malad.
But there is an order for
Yes,
preparation,
that
which
is-
makes it another
But it has
new
to
angle out
proceed,
there.
it has to proceed, Malad, but it cannot follow, Malad.
But
So therefore-
but you didn't challenge that order for preparation of the comparative justice statement subsequent.
Well, that is my case, Malad.
But yeah, but you didn't challenge that order.
That order was passed on at my BS, man. That was passed on my BS. I find it.
Understood. You didn't challenge
did.
that order.
I didn't share.
So, Another said this court now has to say that my brother was wrong.
No, what I say, Malad.
How do I say so?
I'm not
Because of
telling
the
you that.
fact that there was a direction and accordingly they prepared the.
Well, they prepared it, but they prepared it subsequently, Malad.
Obviously, this has been done pursuant to the order passed by
True,
the
madam.
court.
But then,
But the court gave them the authority, though, now you prepare and thereby made it.
So
You
court's
should
order-
have challenged that order.
court's order could not have been interpreted to say, Malad, that it can be prepared at any point of time. It has to precede, Malad, the selection.
But the court directed you prepare.
That's true. That is.
And if that is so, you give up waiver, acquisitions, whatnot, everything comes into the
And the
picture.
other Malad, ground is that, Malad, that the board did not authorize the person concerned to Malad, submit the tender, Malad. And that is a requirement. As per the tender, Malad, format, Malad, there is a requirement that the board has to, Malad, pass a resolution authorizing the person concerned to submit the tender. Here, Malad, the board was not non-existent at that point of time. It was under suspension, and subsequently when it was, Malad, reviewed by the
It's a cooperative society.
cooperative society.
So at that point, in a cooperative society, it was suspended.
Yes, my lord, it was suspended, my lord. And in fact, my lord, when it was, my lord, renewed, my lord, the board's tenure exists, my lord, was, my lord, over. My lord. It was, my lord,
It was done under Assam Cooperative Society.
yes, my lord.
So that it was not suspended, means it was dissolved.
Dissolved, my lord, it was dissolved.
And one-man committee was appointed.
Yes.
So
There was no authority, my lord. The one-man committee did not apply, my lord. It was the, my lord, the secretary, so-called secretary, he applied.
No, understood. But
there is-
at that point of time, there was no board.
No, no one authorized him, my lord, to submit the tender, my lord. That is also one of the conditions. Ground, my lord.
You cannot, but the question is, if the board was not there, Huh? No, but the cooperative society having been dissolved, a one-man committee is appointed under 41(6).
Yes, sir.
But with the one-man committee, does the secretary also loses his job?
Well,
The
some-
secretary
No,
remains.
but the requirement, my lord, the requirement, the form, and which I brought in my affidavit in opposition, my lord, reply. It says, my lord, it has to be authorized by the board. Or, my lord,
No, if the
if-
board is not there, secretary will have that.
Whether-
The one-man committee will.
whether that one-man committee's, my lord, approval is there, that is to be, my lord, kept in mind. If the records do not reveal that one-man committee's approval was taken, my lord, that tendered paper ought to have, my lord, contained that board's resolution also, or the one-man committee's approval also. Whether that was done with, this tender was filed with that, document. That's from the record there to see. Whether what they're trying to say is that we go by what they've submitted. They ought to have insisted that.
Let's see the NIT.
And I think, my lord, the conditions, my lord, I have brought in record, my lord,
We are taking 941, your petition.
in the form, my lord, in my, my lord, affidavit
What
reply,
is
my
the
lord, I've brought-
tender notice?
form.
Yes, got it. Seal tender notice, so and so. Where's the tender?
my lord, the form, my lord, page 14, my lord, I have brought in, my lord, by an additional affidavit.
Seal tender,
Rather, affidavit
hereby
of reply.
invited from so and so, the tender documents along with here may be collected. What are the tender documents?
My lord, page 14, my lord, second clause 2, my lord, call.
Page 14, annexure A.
Well, of my affidavit reply, madam. This is the form which has been submitted, madam.
What are required? Yes,
My lord,
page 10,
second one, madam.
page 11.
Page 11 is the English version, madam. Yes.
If the bidder is a member of the cooperative society, then his name, full address, by whether the name. If
Whether the
society
tender has a
is
resolution
secure
authorizing
as
submit the tender,
against which
is available.
normally they are bidder petition.
And the-
Certificate, minimum registration certificate. Where?
My lord, clause 2 call, my lord.
Huh?
2 call, 2B.
Who?
2B. Whether the tenderer has the resolution authorizing to submit tender is available.
Where? 2, 4.
Yes, my lord. Page 14 is the vernacular version, my lord.
11, whether the tender had resolution.
Yes, authorizing to submit tender is available. Xerox copy of the resolution to be annexed.
No. Whether the tendered.
It goes up to a tenderer.
Oh, we go by this. It doesn't makes any sense. Page 11, 100.
Page,
Yeah.
page 14 is the vernacular version.
Why should I go into the vernacular?
It says whether a tenderer has
Well,
a resolution authorizing to submit the
the
tender is available.
Constitution has stated that the
Ex-
High Court proceedings are to be taken in English.
My lord, Xerox copy of the resolution to be next. My lord.
Absolutely, I'm not going to. I'm going as per 11. What you have certified is to be
Madam.
true.
Whether the tenderer has a resolution authorizing, my lord, Xerox copy of the resolution.
Whether
to be next.
tendered has
It is
the resolution authorizing to
Ten- it
submit tender.
tenderer, my lord, actually.
We go as per what.
Even otherwise, my lord, Xerox copy of the resolution to be next, my lord. The
Xerox
second
copy
line.
of the resolution is to be annexed. Okay, we get the records.
If they have it, my lord, I won't have any, my lord.
The short matter
No.
on that. Huh? Okay, we have it on some other day. In the meantime, Mr. J.L. Borbuya can also get those citations, which obviously is not there. You hope Mr. M. Datta's case strikes. Because we have to set and direct for fresh tender, na? That is the only way. Oh, by that you are out. He'll be out. You are number one, na?
Otherwise, if he comes in, I'm out.
Okay. Means helping both the petitioner and the respondent. Something like that. Okay. This matter again on 13th November 2024, on which date the Mr. P. Sharma, the standing counsel of the Fisheries Department of the government of Assam shall produce the reports.
Can it be 12 or after 17 to 15? Senior will be again 14, the first admission will be again from 13 to 17.
Mr. Counsel, why don't you go there, talk to the President of India and tell him that on behalf of Mr. J.L. Bhuya, there should be one court whenever it is convenient. Don't come up with, ask somebody else to appear. You are there. Don't come up with all these things. I have taken your consideration today that you are in difficulty. You have not read the brief properly, may have been. So therefore, I have permitted, I have given you an adjournment. But don't take it that every time it will be like that. Why should I have it on 12? Well, there are a lot of other matters. You see, we must be thinking that this court only fixes this here. These are all these matters which are fixed. Only see how many matters are there already. So many matters. It's so easy.
Item 15.
Yes.
There we have challenge and order passed by the Board of Revenue.
What do you want here?
Set aside the order passed by the Garnet Revenue Board.
Revenue.
Revenue.
What is wrong with the order?
Wrong with the order. There is a partition order was passed by circle officer. Accordingly, partition was done. Separate patta has been issued and we have been paying land revenue. Subsequently, they have approached before the revenue board, and the revenue board set aside the order by which the partition was allowed only on the ground, basically that there is a building.
What is wrong with the order? It has a building?
It has a building.
So, not possible. See order 20, rule 18. It is only the land which can be partitioned. How do you partition the building?
We are in the amicably possessing the building. We are both responding.
Whatever may be, can the partition court say so? That's the problem
Not
arises.
wrong, Your Lordship.
See order 20, rule 18. You are referring to which one?
Assam and even regulation.
You are referring to section 199?
Yes.
It can only partition the land.
But
It cannot building. Because the moment the building comes, the partition has to be done by a commissioner in terms with order 26 rule 13.
I may be wrong, Your Lordship. 110 of the Assam Land Revenue Regulation says, if in the making of partition necessary to include a state assigned to one sharer in the land occupied by dwelling houses or other building in the possession of another or co-sharer, the other co-sharer shall be allowed to return it with the building thereon.
But, Mr. Counsel, I hope I'm not I'm not being able to convey it to you. You will require at the time of partition which portion of the building belongs to whom?
But yes, your lordship,
How
Very-
will you get there? Tomorrow there will always be a bigger issue as regards the building. You see, when there is a land as well as the building, you cannot do so. Therefore, what the court, there has to be one preliminary decree as regards the building, land, or if it is cannot be, kindly see order 20 rule 18.
order 21.
Order 20 rule 18.
Decree in suit for partition of property or separate possession of a share therein, where the court passes a decree for partition of property or for the separate possession of a share therein, then if and insofar as the decree relates to an state assessed to the payment of revenue of the government, the decree shall declare the rights of the several parties interested in the property, but shall direct such partition or separation to be made by the collector or any gazetted subordinate of the collector.
So
deputed-
therefore, let us take an
Yes, yes.
example of 1 bigha of land is there only, nothing more. Then he will say that these are the 3 persons, so everybody will get 1/3. Court will only decide them. Then as per 54, he will do it. So the decree is already there, it's a final decree, it's no preliminary. And you see order 18 rule 22. Order 20 rule
Yes, yes,
18.
Order 80.
Order 18, 20 rule 18(2), the second one.
Yes, yes. If and insofar as such decree relates to any immovable property or to movable property, the court may, if the partitions or the separations cannot be conveniently made without further inquiry, pass a preliminary decree declaring the rights of several parties interested in the property and giving such further direction as may be required.
So there, in that regard, what he will do is go for that under order 26 rule 13. So it has to be done by them. And thereupon he will do it. Now there is one provision, if you see the Assam Land and Revenue Regulation 106.
Partition of land, some of which are held in common.
So there is a scope left as regards 106. But to get a right over that portion of the land, you cannot get it by way of an affecting a perfect partition in terms with that revenue.
But as regard the possession is concerned, see, there is no dispute between the parties. With regard to the building,
You want what?
there are two possessors of the building. I have filed for partition. They received the notice, did not appear. So,
How do you partition? Isn't the building a part of the entire land?
yes, yes.
So how do you partition it?
Partition, for partition, we have to approach the definitely with civil court.
So therefore, the only way out of partition is by a civil court, which has been rightly said by the Assam Board of Revenue. That is what I'm
But
saying.
land has already been partitioned.
You see, once it is being partitioned by the court, it will already due effect will be there. But how will you get the title over this particular portion? You
Building
cannot
portion.
get it.
As it-
House, as of now, if a building just in a 1 bigger plot of land, the building is standing. Are you in a place, are you agreeable that in the area where there is not the building, you want to take that and the remaining with the building will be taken by the other one? Are you agreeable to that? No.
Mutually, in fact, mutually, we-
How do you do it then? Means you are to have therefore the proportionate rights in respect to the land, which is
proportional.
something like the flats,
Yes.
proportional. So that can only be done by through a civil court. So what is wrong with this order? You should go to the civil court.
For the purpose of land and building both.
Absolutely. Then, no, then you get the title. Problem is this, you need a title. Just for example, the building has 3 floors. You want the ground floor and the first half. How do you get? Either there has to be a mutual partition by which written everything is done and which can be, you can register it, or if it is not also registered, it can be done. But later on, if a suit is being filed, you may have to. But otherwise, you have to get it in a suit. saying the declaration that this is the ground floor is here, first floor is yours. There will be a question of OLT also. Person who is living in the ground floor, the value of the property is more than the first floor. So these all various aspects can be only decided by the civil court. What is wrong with the order?
And your lordship, kindly, as regard the partition of the land is concerned, patta has already been issued. Patta separate, patta has already been issued. And we have been paying land revenue also.
Then what do you want?
So that party be, that, of course, that part cannot remain. If
But how can there be? Again, the problem will arise. Is which portion means again, a person will say that this building is standing on part of this building and part of that dark. Again, the problem arises.
I mean, sir, you know.
No, you don't leave it. I'm just explaining to you the problem which is there. At a later stage, you may think, yes, this is not, you may have a problem. Because tomorrow, for example, you want to do something in respect to the land, in respect to the building. The building remains, you can do it. Or construct one floor above. You do it? No. You have only the land. And it is bifurcated. Therefore, the Board of Revenue was justified in doing it.
Before coming to
Kindly
the-
come to paragraph 7 of that order, page 74.
The existing building can be partition following some specific provision of Code of Civil Procedure only, and Revenue Code Authority has no jurisdiction to partition the particular building attached to the land. And without following following rule of the procedure, civil procedure, and without partition of the existing building. So partition of the land alone would not legally viable as per law.
When we take the civil bench one, we find a lot. If this person goes and to the village, in some villages, this person goes and puts a no objection in the particular the hereditary rights that I have no objection in the area. But the fact that whether that no objection would amount to a relinquishment, no. So there the problem arises. And this revenue partition, you may be given a patta out there, which has been done, it's a different thing. But how is it actually going? That patta may help you out. In a civil suit, it may help you out. But the problem is, how are you going to do this? Otherwise, also you are entitled. How many brothers and sisters are there? So,
Brother and sisters.
therefore, it is a question of both of you are entitled to. Unless you want that, okay, building is gone this way, I want this. For this particular area of land, I want to make some construction.
The problem is that you also just put it that I cannot sell or I cannot take loan against my share of property. That is also there is a problem. There is a problem. And he is not coming forward for partition amicably because it has to be divided equally, brother and sister. So I apply for partition.
But there cannot be a perfect partition.
Of course.
If there cannot be, the moment he opposes on the question of
In
title,
fact,
or
it
anything,
was not opposed by them when it was before the circle officer.
he didn't get a notice. That is what he is saying.
No, but the
But the
appeal
court
order-
held that he was given a notice, it was given and all, but that is why he did not object. But the moment he would have objected, the jurisdiction on the 100 would have been, the DC would not have the jurisdiction.
Or revenue board also held that he has received the notice.
But the fact that his cases I have not received, otherwise I would have objected. So you want to prolong your agony for another 10, 15 years, we can admit the matter and keep it for hearing. What do you?
You must say, I need to take instruction, it may be after 2 days.
Better. Means I'm telling you, because later on you may have another problem. How will you do that, Santiago? Mr. J. Bush appearing on behalf of the learning
And
council.
summary.
And some,
and
and some.
counsel, appearing on behalf of the learned counsel for the petition, submits that he may be given some time to obtain certain instructions in the matter, taking into account the impugned order. List this matter again on 13th of November 2024.
And 17.
In item number 16, no affidavit has been filed. So my lord, lordship may take up item number 17. 16 of the pending affidavit.
Huh?
No, so for 16 is concerned, I have
What are these cases? Which case?
17, lordship may take up item number 17.
Anyway, what is the case about?
My lord, one notice inviting application for allotment of rooms at Chapel Municipal Market was issued on 26/10/2018. Then on my lord 25/11/2018, rooms were allotted to the petitioner. And on 21/1/19, agreement was also made.
With you?
Yes, with all the petitioners, and money of 1 lakh was deposited. Then my lord, rooms were not handed over. Then they have cancelled the allotment and issued a fresh NIT. At that stage, we have approached this honorable. And there is a stay order of it.
Agreement?
My lord,
Agreement?
agreement is there, my lord. They have not, they have just issued a notice saying that you take back your money. And then they had gone for a fresh.
So you have handed over possession also?
No, possession, physical possession was not handed over. Agreement was made, but we refused to accept that money and challenge the NIT, which has been stayed by this honorable.
What is your case? Why have you done that? Read. Okay.
Then therefore your lordship will find the allotment order at page 18. This particular allotment, lordship, the entire distribution is based on some legislative document. One have to take record of this as well as the allotment. So there is the page 18. There is no file number, no record. Nothing has been written in the allotment.
Where?
Top of the page. Numbers.
Oh, nothing. Only date is being given. This is being done by then chairman.
Yeah.
Yes.
Then
By way of this,
agreement done by whom?
The same chairman.
Chairman.
Yes. Agreement.
thereafter lordship may take this but it's very shocking. It's page 20. Agreement. This agreement was signed, executed between the petitioner number 2 and the bench government. And Haki Sohi was to be signed. And page 20. So what is the?
Who are they?
The bench government signed by the bench government. And Bharatiya Sohi, the petitioner number 2. And Haki Sohi, this is the son of the bench government.
Huh?
This is the son of the bench government, Promise Ahmed.
Then
So this agreement was not signed by any of the board members, not by the executive member, executive in terms of the section 4 of the act. So as to make this contract binding of the.
then
Thereafter, lordship, we have annexed some proof to the. Please, okay, we say that we do not have the record of this particular resolution dated 28/6/2019. Because of the fact that we cannot issue such, we cannot do such resolution. The lordship, there is our applicable position.
when was the agreement agreement entered into?
My lord, the agreement was entered into on 21/1/2019.
21?
1/2019.
Okay, so it was subsequently again agreed, approved.
My lord, there is some development, my lord.
Wait. Your simple case is, there was an there was a notice issued. Pursuant to that, you have participated. After participation of that, you were entered into an agreement, allotment was given, agreement was given. They have taken you 1 lakh, but they have not handed over the possession. Now they are making an attempt to again re-tender. This is your case. I'm seeing the facts of the respondent. Let's see. Then what happened?
It was for 25. Agreement was for 25. Clause number 3 of the bill number 20. For 25 years, the lease was granted in favor of the recipient. Prior to executing this agreement and issuance of the fees, dated 26 times, there was no approval of the director of administration. For under 1(8).
What is that?
Okay, so what about the-
No, don't. Now then what happened?
Judgment to go.
Now, does the chairman have the power to call for a tender without a initial? There being a resolution taken by the board.
Chairman does not have the power because there are no board resolution was adopted. prior to-
Initial. The subsequent means by a subsequent conduct or post factor, you cannot regularize something which has been done illegally.
Chairman issued the allotment order. He was the chairman, he was the same chairman who initiated an allotment to board meeting on 26.
No, that I understand. My therefore question is, as per the Assam Municipal Act, is it permissible for the chairman on its own to go ahead and settle without the prior board's resolution to do that? Let us see that, because I don't think the chairman has the power to do so. Where is the Municipal Act? Post facto approval may not help. And Mr. Council, you are coming up with that small, yeah. Anyway, there are some municipal act. Yes, Mr. Sokapati. Is it permissible for the chairman?
My lord, in their affidavit in opposition.
No, forget about that. I'm asking you. Is it permissible for the chairman on its own, without the board's resolution, to go ahead with a tender process and make the settlement? And thereupon be regularized by a post facto approval? Guwahati Municipal. No, Guwahati Municipal. Guwahati is Assam Municipal. Tell me that. That is the specific question. Answer, we have, your matter gets disposed.
In that case, I'll have to examine because this.
What is there to examine? This is the
May take
issue.
up- My lord, it is not the pleaded
Then-
case in the affidavit that the municipal chairman.
Okay, you go ahead with your tender. And then one fine day, if they win the case, when Mr. Chokopati is ready, we will see.
Lordship may
You'll
take up this
issue
matter
to
tomorrow, my lord.
Vacate the interim order, and thereafter, you go ahead after 10 years. But give a contract only for 10 years. New one. So by the time the reputation will be there. Show me that provision. Where is it permissible? The power of the board, can the chairman on its own do so? I don't think so, because the chairman's power is given somewhere. I've seen it. Yes. The chairman shall, for the purpose of transaction connected with this case or for the purpose of making an order authorized thereby exercise all the powers inherent by the act of the board. Provided chairman shall not exercise any power which shall be exercised under the rules by the executive lay of service appointed, provided also the chairman shall take any position. Anything contrary. So without the authority, how can he do so? It is the power of the board. You are referring to which section? Municipal way may do. You are referring to one judgment of minor? The board may enter into and perform any contract. Every contract made on behalf by or on behalf of the municipal board in respect of any sum exceeding 500 rupees or which shall involve a value exceeding 500 plus shall be sanctioned by a board at a meeting and shall be in writing and signed by at least 2 members, one of which shall be the chairman or the vice chairman and the executive officer, and shall be sealed with the common seal of the board, unless so executed, such contract shall not be binding on the board.
Please,
Okay.
22. The only signatory to the contract is the son of the bench here.
And he's not, nothing to do with the board.
Yes, that contract is not binding. Therefore, the entire petition, they are straight.
And without it is the board who has to do it. Board has to authorize the chairman to do it. If we go as per 37 also. The board may authorize the chairman, okay, you go ahead, initiate the tender process and all these things. But that is not been done.
Board by way of various
So, Mr. Suman Chakraborty, now you have to go to the division.
Now, my lord, in the fresh NIT also, that is on page 52, it is not the case that this is also approved by the board. The fresh
Whether it is approved by the board or not, I'm not concerned, but the fact that you're right, you are before the court.
My lord,
You say that your right had accrued upon you and on the basis of that, the fresh NIT should not. Now, have you raised the issue out here that the board did not authorize the issuance of the NIT?
no, my lord, here their only stand is, their stand is that the agreement was executed, the decision was taken at the time when model code of conduct was enforced. That is why that they have decided. Lordship may have a look at the affidavit.
Forget about the affidavit, but the fact is, this is clear. It is not done by the board. Show me where it has been. You say the board has only posthumously approved it. But whether there was a direction by the board earlier.
It is also not the case in the affidavit that the initial NIT was not with the approval of the board.
Not the case.
Yes, Lordship may have a look at the affidavit. What he is arguing is not there in the affidavit in opposition.
Points which I have are not in there. Certain points. However, they-
Huh? Speak loud.
Transferring the- It's not very of like to argue the other.
To
Argue the other.
argue without affidavit.
At page 77, paragraph 7.
What is that?
It is- Certificate says that the file does not contain the file number. Purported agreement shows that the witness signed the purported agreement is coming from. a-
It is a scheme that in pursuance to so and so, so and so, so and so.
Does not contain.
That the same does not contain any file number or memo, and that there is an overwriting of the month and also that we have never received such letter without containing file memo and by. For the page of.
So this is the only affidavit that I was not with. Which affidavit you are referring to?
Oh, prior to that, there is already an order of cancellation by the board. Huh?
My lord, the affidavit which my friend is referring to is not served upon me, my lord.
What?
Yes.
You say that item, you have saying,
no.
kindly take up item number 17 because there is an
the
affidavit.
affidavit which my friend is referring to pertains to item number 16, a copy of which has not been served upon me.
I'm taking up which item? Not 16. I have taken up only one matter where there is an affidavit. Yes, item number 16 only affidavit is there. That is by respond number 4 and 5.
16,
Why you are saying that it is not there? It has been
but
received
the
by
copy that has been served upon me is of item number 17.
item number 17. What is this item number 17?
There are
That
two
is-
writ petitions, my lord. One
No,
is
that in 17, we don't have an affidavit. We don't have an affidavit in 2407. We have an affidavit only in 2696.
But the thing is, my lord, the copy that has been served upon me is of 2407. And-
2407, there is no affidavit. with it.
Yes, the
Huh?
affidavit copy which has been served upon me is of 2407.
Anyways, whether they, in that thing, paragraph 7 is there or not. No, point is there. Hello, we dismiss and log FIR. FIR.
The petitioner number 1, the person favors the allotment was made. Petitioner number 1 is they entered into an agreement, and then the petitioner number 2 has entered into an agreement with the bench chairman. Because the petitioner number 1 was having some financial difficulty. So therefore, the petitioner number 2 does not have any locus to file this petition because there was no allotment order in his favor also.
Lordship may come to the main paragraph 5, my lord. Paragraph 5. What is their whole case, ma'am? The answer in response states that due to illegal conduct and action of the chairman so and so, we convened a meeting on 23/19 at about 3 p.m. in presence of the members and vice chairman. It was decided to lodge complaint against the chairman, Chapel Municipal Board. In the aforesaid meeting dated 23, it is also noticed that the chairman municipal board allotted some rules in favor of the petition, including.
What will the court do if there is a manipulated document placed before this court?
The document which petitioner is referring, this document does not entitle him of any right.
No, what should the court do if a manipulated document is?
File a FIR.
No, should this court initiate proceedings under 340? The CRPC, oh, now it will be some other, another provision. What is it? As
Well,
per the
they are
new-
saying this is manipulated because they don't have any copies. That is why it is not even the case in the affidavit.
Produce the original one. Produce the original one if you have it. They say that they don't have it. They say that the question does not arise of approving when we have already cancelled. Prior to that, they cancelled it. Kindly see this, that is what I'm saying, paragraph number 7, kindly see. Page, paragraph number 7, just before paragraph number 8, it is written. It is further stated that the board's meeting were held on 23/2019 and 2/4/2019, wherein resolutions were taken to cancel the rooms illegally allotted by the then chairman so and so, which is signed by members, by members, namely so and so. And therefore, the question of having another board meeting on 28/6, month after that,
Yes,
with a resolution to allot,
that is,
with a resolution to allot in the Emmanuel does not arise under any circumstances. And therefore, the so and so is absolutely fake and fabricated. document.
yes. Now, my lord, lordship may permit me to submit it. On 23, they have removed a no confidence motion against the then chairman. And this honorable court has stated that and directed the chairman to continue. I have that order, my lord.
I'm not concerned with that.
Yes,
But
my
the
lord.
No, but the fact that there were 2 resolutions passed where it was cancelled. Which board
My lord,
did it?
that resolution was taken to remove him and this honorable court directed the lordship may have a look at this order.
We direct the police inquiry on this.
And
No, we direct.
lordship may have a look at this
No,
order.
no, not necessary.
This chairman. the
We
other chair-
direct a police inquiry as to whether this document is fake and forwarded, and how did you get the information of that document? Tell me. The chairman is not here before this court, so how did you get in possession of that document? The
That-
chairman must have given it to you.
That we have to get the instruction
No,
from the
no,
client.
how did you get? You can't get a possession of a document which happened subsequently.
My lord.
I would have understood you got some possession of document prior to that. You may have kept it. After that, how did you get it?
Now, my lord,
That
the
too when these
question, my
people
lord,
have
the
cancelled
question,
it.
my lord, the question that calls for an answer is whether on 28/6/19 that this chairman was holding the office or not.
I'm not concerned with that. The question
Because
is,
the
no,
board-
first
the-
and foremost, the question which begs consideration is, did the chairman have the authority as per the board, with the board for allotting? That is the question. Without that, it cannot be binding on the board. That is clear. The law is very clear. But I am only asking what future action can be taken
My lord,
against
their
such
stand is
applications.
that it was since that they have taken a resolution on 19th.
Anyways, we take it up again after two, one, Mr. Kenshaw's matter is there, then you take up your matter.
Well.
Think about it, what to be done. Should we initiate?
Let them serve a copy of 2696. They have not served me a copy of the affidavit in 2696.
Take the 2696. Give it to him. I also have only 2696. I don't have
The thing is, my lord,
2407.
they have filed
But the
affidavit in
fact that-
2696.
But the fact that in the other one also, the contents is verbatim the same. Except two paragraphs must be put out there that the first one, the second petitioner does not have the locus.
In the limited space, my lord, I will make one submission. If you lordship to kindly have Jaspal Singh for a minute. Now, para 18 is about the facts of the case before the Supreme Court. And generally para 23. Before parting with this case, we give direction to all state governments in the country that they should prepare schemes for eviction of illegal unauthorized occupants of Gram Sabha, Gram Panchayat, so Shamlat land, and this must be restored to the Gram Sabha Panchayat for the common use of the villagers of the village. For this purpose, the Chief Secretary of all state government, union territories in India are directed to do needful, taking the help of other seniors officers of the government. The said scheme should provide for speedy eviction of all illegal occupants after giving them a show cause notice and a brief hearing. Long duration of such illegal occupation or huge expenditure in making construction thereon or political connection must not be treated as a justification for condoning this illegal act or regularizing the illegal possession. Regularization should only be permitted in the exceptional circumstances where lease has been granted under some government notification to landless laborers or members of scheduled caste, scheduled tribe, or where there is already a school, dispensary or other. But what I was trying to submit for lordship's kind consideration is, first of all, my lord, our entry into the land is not illegal. There was a valid permission from the authority. And my lord, that too, under the relevant policy of the state government, this measure of giving this land was taken. And otherwise also, my lord, under the settlement rules under 95A, a village grazing reserve can be de-reserved also by following the procedure.
Unless there is a case of de-reservation by virtue of 95, by virtue of 95, you
Yes.
could not have entered.
No, my lord, that record is not before a lordship. I think government will have to show that this 95 procedure was not followed. It was a vizier and it was de-reserved.
Is it your case that it was de-reserved? It
Otherwise,
is
how can
not your
they?
case. No, it is not your case
No,
that
but
it was
otherwise, how can
de-reserved.
they give? Without de-reserving, they can't even give us.
That is what was the problem. That is why these directions were passed in Jakpal Singh. There also allotments were being granted by the
Here
municipal.
not there. If your lordship will kindly see para 18. Para 18 is the facts of this case. Present is a case of land recorded as village pond. This court in so and so held that land recorded as pond must not be allowed to be allotted to anybody for construction of a house or any allied purpose. The court ordered the respondents to vacate the land they had illegally occupied. After taking away the materials of the house, we passed similar order in this case. In this case, my lord, a village pond was thought to be illegally occupied. Well, another, in end of the day, my submission would be, my lord, since under the land policy, there is a scope for regularization also.
No regulation for the land policy is very clear on that. Under no circumstances.
Here also I find one sentence, my lord, that these three categories will not be
But you
relaxed.
don't fall in those categories. Neither you are an SC, ST for that purpose.
SC, ST or scheduled tribe. Anyway, my lord, I leave it to lord. I thought, my lord, our permission was there. It was not an illegal entry. Only thing is, my lord,
First of all,
since this para 23 itself recognizes a scope for regularization, will apply, my lord, government will consider, not a positive mandamus, but will apply, my lord. If your lordship would kindly see, regularization should only be permitted in exceptional cases. Since our entry was not unauthorized, we'll apply and the government will consider according to the existing policy framework. If they don't give us, it's okay, my lord.
then
But that is my,
what to do? Should I dismiss it or should you withdraw and I give you the liberty to apply?
my lord, let the stay order be operative for a 1 month and I'll withdraw this, we'll apply, my lord. Government will consider.
Or you do one thing. You submit your representation. I say take disposal of the representation, no action. should be.
As status quo as on today will be
Not
maintained till,
necessary,
yes.
because I say that till disposal of the representation, no action. will be taken. But you
No
submit
consequence.
within 15 days from today.
Let it be
No.
4 weeks, my lord.
You submit a representation.
Oh, well, within next 2-3 days, we
No, no, I'm giving you,
Yes.
submit your representation within 15 days. Until disposal of the representation.
Okay.
in the
irrespective of the
meantime,
time
I
frame.
think you can do that.
Yeah.
I think that is a better option.
Yeah.
Why there are same petitions by same?
Three
person?
petitions, my lord. Not same, my lord.
There's a writ appeal also. Oh no, the one is 1092.
Sorry, not mine, my lord.
Oh, one is Das, Khanindra Dat, one is Khanindra Nath. Gayan.
My lord, our cases are 1092 of 2017,
Number 7.
789.
You submitted something before the authorities? No.
No, my lord.
What is this annexure L at page 67
One
in 1092?
second. Upayukta, this is no deputy commissioner. I think you'll have to be before the state government. This is before deputy commissioner.
No, this is the, yeah, no, representation.
Page
You, no, you are
63.
going to submit to the deputy commissioner only.
No, my lord, I think
Against rule 18, you submit there only, you don't submit to the state.
regarding, my lord,
No, that is a different.
yes, rule 18 years for deputy commissioner.
Now, has this been disposed of? No.
No.
And without that, and you have given a copy also to that.
Yes.
So you need not submit it. These are already there.
Already there.
So let them take and consider the, yeah, and, I give you 15 days for submission of
I
an
think
additional
next
document.
one.
Huh?
One of them. The file fresh. Have to be filed.
Yeah, I will file 4 judgment, I'll give 4 judgments separately because each has a different.
Facts are-
The facts should be different. Facts are almost same, but here they are coming. Yes.
Pursuant to an order passed by the Revenue Department, lordship is allotment was given temporarily for a period of 3 years, not beyond.
But have you mentioned these to be Bhatkusi Cattle Reserve?
It's a
This-
visual land, there's no doubt about it. Hatkusi Vijaya, under Jonia Muda.
Are these all notices similar?
The my lord, revenue village is same, but Vizier is same. In 1091 also it is same. My lord, on the very first page synopsis, that schedule is there, my lord.
This is a submission to the letter. This is by Prophet Agya. It's same.
Same.
Monojit Bormon.
Manojit Burman and Manoranjan Chaudhary.
All are same, na?
Yes. Only that.
And
land
all of
part-
you were initially given for 3 years. Settlement. Not settlement. Where is the settlement? How
Yes,
you?
yes. That order is there. Page number 18. Was the bottom middle. Deputy Commissioner had forwarded to us the government's order. Effectively at page 19, with reference to above, I am directed to say that Governor of Assam is pleased to order for temporary allotment of 20 bighas of land under that number so and so in part 1 of so and so. With Pavitra Kumar Das and Khanindra Nath Bayan on behalf of Rupkor Ita Uddog for brick industry for a period of 3 years on realization of royalty as instructed by.
So there was a draft agreement.
Yes, there's an agreement also,
No,
followed by.
no, was it signed? Then why did it say to be draft?
This is how. We have to go through. Page 35, Miller. The registered one. Page 38, that is all there. Right. Altogether.
And thereafter you have been paying, have you paid anything?
Yes,
What are you paying now?
the revenue, annual revenue was paid, Miller.
How?
Of course, recently I don't have, that instructions we don't have.
No, how are you paying? Means you don't have your settlement.
That
How are you
annual, that annual thing, Miller, because.
You are
because-
paying, you are a lessee.
Exactly, my lord, our status is of, yes, let's see, because there is an agreement. There is an allotment of land. What will you describe to you say? No, doesn't describe as lessee, first party, second party. Yes.
Payment of rent revenue as paid off for the they are paying the paid off.
Where?
It's only 109,
Who has filed the affidavit?
by the circular.
Circle officer is relevant.
No, but the allotment order says otherwise. Allotment order says yearly on realization of royalty as instructed by government dated, later dated 26/5/86. সেইটো হ'ব গ'লে এইটো তৌজি বাহিৰা। It's not তৌজি বাহিৰা. This is royalty.
If it is a royalty, if it is an agreement entered into, can you exercise 12 or 18?
Rule 18.
Because we are concerned, maybe VGR lending you 6 steps for vacating by filing suit. But the fact that you have entered into an agreement, you have not cancelled this agreement. And by operation of law, by accepting the rent, you have been accepting it.
Not rent, royalty.
No, they said it to be dead rent, you see. Page 37.
Yes.
The first party shall be liable to pay either dead rent to be fixed by the DC SDO concerned or
Yes.
the royalty at rupees 2.50 per CM,
Yes.
whichever is higher for the lot. Then is VGR land that the first party shall not cut earth from any public road that shall not operate the brick industry by jeopardizing any railway line. The first party shall not collect brick earth in portion of 60 meters down the railway line. Must dug earth under so and so, the first party registered so and so shall not violate the stipulations, conditions if the reserve happens. And if the reserve, the DC concerned shall have a right to evict the first party after. What does it mean? Paragraph 10, clause 10, page 38.
Yes, that the first party shall not violate any of the stipulated conditions. And if the reverse happens, the DC SDO concerned shall have right to evict the first party. First party?
Forthwith, I think.
Yes,
Forthwith.
forthwith. So, my lord, as your lordship has rightly said, my lord, Rule 18 prima facie, how does it apply, my lord? It's not that we are not an encroacher, my lord.
And if this is the basis, then how do you apply Rule 18? It is not a question of settlement. Here, you have illegally done it. But Jakpal Singh, if you see, finally see Jakpal Singh, what has happened? Finally come to paragraph 6 of Jakpal Singh.
Yes, it is neither owner nor tenant of the land in question, which is recorded as pond situated in village. And moreover, my lord, 18(2), it speaks of bona fide right to right of claim of right. Rule 18(2). Further, there is no bona fide claim of right in. Then the Decas case comes in.
Our means Rule 18(2) means even in the DECA case also, they have presumed it something like a bona fide claim. It is not a bona fide claim. It is a bona fide claim of right involved. Right involved means you have a prima facie case.
Right.
If you
To
have a
hesitate.
prima facie case, you can't resort to
That summary procedure cannot be.
That is what
That is the underlying principle.
But in other cases, if they have taken into consideration bona fide claim in a sense of similar to a 434 proceeding in a company where it's a bona fide claim, then obviously it's a dispute. It's a bona fide dispute, or in a land acquisition, in a land, public premises, if you have a bona fide right claim out there, dispute out there, they should not. But here,
I think Lordship is also aware of one division bench judgment of our High Court, my lords. Not Kamalakanto Deka, that is Daulat Ram Lakhani, where even that civil court thing has also been clarified.
Daulat Ram Lakhani, Justice Hansari has
Hansari.
judgment. There's this Supreme Court says that if it is in a case, the full bench said that if it is the case where the jurisdiction is involved, then obviously
outside of
you
jurisdiction
cannot
cannot
oust
be
the
readily
jurisdiction of the civil court. And another very interesting aspect which has been stated out there is the provision of section 154A is only to safeguard these revenue officers for the period in view of the holding that section 154 rule 18 to be ultra vires and violative of article 14. That is a very important aspect.
Correct.
Which has been stated out there. But if these are agreements, the agreements with the government, you have to cancel those agreements. And for cancelling these agreements, there has to be a process of law followed. How do you take care of that?
And third party promises of plan after expiry of the term of the agreement shall be complete. The term of the agreement was 3 years.
So, Mr. Sharma, tell me one thing. Then whether the state government is immune from the transfer of property act. No, so forget about it. Yes, Jakpal Singh is there. You want to evict them in view of Jakpal Singh. You have to tell them that we are cancelling it. This is an agreement.
Thereafter also,
continue.
my lord, they'll have to file a suit.
This is an
for
agreement.
eviction.
How do you take care of an agreement? Normally, if a person is in possession by any grant, it's a different thing. Till the letter is being written by the governor, this court would have said that no, that is bad. But if it is an agreement to pay rent, meaning thereby the state have committed all the illegality, but it is for two judges here to see it, to say that on PIL that this is wrong. Isn't it? But how can I say out here when there is an agreement that you resort to?
Some of the cases, the agreements are not
In all cases, the agreements are not.
There.
one or two.
Once, let me see. sir. দেখি তো agreement আছে তো আমার।
Yeah, in these cases also there is an agreement. 1091 Bonojit Bormon.
Yes, it is. Page 28.
Here also,
Yes,
page
page
39.
39. আচ্ছা, আমি কি শিখতে গণজিৎ বর্মন মনোরঞ্জন চৌধুরী।
In 1396.
Because now what you are trying to do, you are trying to evict.
In any case, 18 will not come.
18 can't be done because it is you have given on rent. Tomorrow, the same thing will happen. The government comes up out there and you give on rent any place out there, you then throw him out. In this case, there is nothing out there. No agreement. Whose case is this? 1396. You don't have an agreement. Then your agreement is not there. Some solace to Mr. H. Sharma. How can you bring this here? Fellow, we dictate. You cannot do so. You want to do so, 18 you cannot resort to. Yes, Jakpal Singh is there, but for that you have to cancel it. Hey, my first eta to koi dim hai 18 ta hoboti 1091, 1092 and 1140. Huh? It will eta ke hobo tumi facts kini silo.
So it will be a lease within the meaning of 105 of PPA.
Yes, that is what, and it will be continuing. Do you mean if there is the fact that they are not paying lease, because that would amount to violation, you can have to cancel it. But you have to cancel it. Without cancelling it, you cannot do so. The heard Mr. Kane Chaudhary, the learned senior counsel, assisted by not you, anybody else. You say that I am not there in the matter.
No, my lord, M. Bharali.
And word. And Mr. Yes, Revenue, what do you have to say? Anything? I'll help it now. Morning hours, it was different. Mr. Evict says he appears on behalf of the respondent number 1. Pollution? No pollution. And Mr. H. Sharma appears for the respondent number 3 and 4. The materials on record reveals that the petitioner herein, 1091 day, petitioner herein was allotted a plot of land at measuring 10 bighas covered by Dag number 235 bracket RA bracket close VZR of Bhatpuchi village in favor of for manufacturing brick for a temporary period of 3 years on realization of royalty at rupees 2.50 per cubic meter and land of 10 times and the land revenue of 10 times of the highest rented class of land in that village. Pursuant to the said communication issued by the Deputy Commissioner and Deputy Secretary to the Government of Assam Revenue Settlement Department, an agreement was entered into by and between the Governor of Assam as well as the petitioner, wherein it was agreed that the land described in Schedule A to the said agreement was being rented out was allotted for brick industry subject to various conditions mentioned therein. It further reveals that against the said agreement, the petitioner had to pay the surface rent for the area at such rate as may be fixed by the government from time to time, the land revenue and the local rate as fixed. Thereupon, the possession of the land was also handed over to the petitioner. So at this stage, it is, however, very pertinent to mention that in terms with clause 9, the petitioner, the DC oblique SDO concerned reserved the right to evict the petitioner if the petitioner had violated any of the stipulated conditions in the said agreement. The record further reveals that the petitioner continued to the record further reveals that the petitioner set up its industry and thereupon continued to function since then. All of a sudden, the petitioner was issued a notice on 24/1/2017 under the provisions of section Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulation 1886. The petitioner thereupon submitted representation to the Deputy Commissioner concerned, Borpeta, as well as the circle officer concerned who had issued the notice. However, as nothing fructified on the such representation, and the petitioner apprehended that action would be taken to dispossess the petitioner approached this court by filing the writ petition. The record reveals that pursuant to filing of the writ petition, this court had issued notice and further state the impugned notice dated 24/1/2017, whereby the petitioner was to be evicted, on the basis of which the petitioner was sought to be evicted. The record reveals that no affidavits have been filed by the, you have no file affidavit.
Yes. 109.
Huh?
On the not Gayam, they have filed. 8, item number 8.
The record reveals that no specific affidavit has been filed in the instant writ proceedings. However, in a similarly connected writ petition, an affidavit has been filed by the Deputy Commissioner Borpeta stating inter alia that the petitioner was temporarily permitted by the Revenue Authority for manufacturing bricks and tiles for a period of 3 years, subject to payment of royalty and Bedahali Zorimona. It was also admitted that there was a written agreement executed with the petitioner and the District Revenue Authority with certain terms and conditions. In addition to that, it was mentioned that at clause number 11 of the agreement, it was specifically mentioned that the petitioner have to vacate the possession of the land after expiry of the term of the agreement without any objection. Further to that, it was mentioned that on the expiry of the term of the agreement, there was no fresh agreement executed between the petitioner and the District Revenue Authority. And as such, after the expiry of the term of the agreement, the petitioners are automatically treated and considered as stranger and unauthorized occupants of the government PGR land. It is further mentioned that such steps have been taking into account, the eviction proceedings was initiated, taking into account the judgment passed by the Supreme Court in the case of Jakpal Singh versus State of Punjab, reported in 2011, 11 SEC 396. Huh? Which department? Let me complete with the DC. Therefore, a perusal of the stand which has been taken by the respondent, the district administration, appears to be that as the period in terms with the agreement is over, the petitioner had no right to remain in possession, and accordingly, summary proceedings under Rule 18 of the settlement rules framed under the Assam Land and Revenue Regulation 1886 have been initiated. More particularly, taking into account the judgment of the Supreme Court in the case of Jakpal Singh, Supra. In the backdrop of the above pleadings, this court has heard the learned counsels appearing on behalf of the parties. Mr. Kane Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submitted that here is a case where the petitioner was initially allotted a plot of land for establishment of a brick kiln industry. Brick kiln industry. And pursuant thereto, an agreement was entered into the same agreement by operation of law, though specifically not extended, but by accepting the dead rent which have been duly paid by the petitioner from time to time, and thereby permitting the petitioner to continue to remain in possession without any interruption. A bona fide claim of right is involved in the instant proceedings. He further submitted that if it was an agreement entered into between the petitioner and the governor of Assam, which is duly admitted, then in such cases, without the cancellation of the agreement and following the due process on law, the eviction sought to be done through a summary mode as visualized under Rule 18 of the settlement rules. Is totally illegal and arbitrary, and accordingly liable to be interfered with. Anything more, Mr. Chaudhary? Yes. Mr. H. Sharma, the learned counsel appearing on behalf of the district administration, has submitted that the agreement which was entered into between the petitioner as well as the district governor through the district governor was for a period of 3 years from the date of handing over of the possession, and the period of 3 years have already elapsed by virtue of clause 11 of the agreement, the petitioner was obligated to hand over the possession of the land in question. The period expired in the year 1995, and thereupon the petitioner, having not handed over the possession and more particularly taking into account that the VGL lands cannot be granted settlement, as well as the judgment of the Supreme Court in Jakpal Singh Supra, the proceedings for eviction was initiated under Rule 18 of the settlement rules. He never submitted that the petitioner has no semblance of right, taking into account that under no circumstances the petitioner can get a settlement over the land in question. And as such, the initiation of proceedings under Rule 18 is in accordance with the well-settled principles of law. Mr. Eviction, the counsel appearing on behalf of the Revenue Department, submitted that though the Revenue Department had not filed an affidavit. Oh, you're fine? Where? 1-3? Oh, that time they're going to dismiss that. There you go. Here you support his submission. Submitted that though the Revenue Department have not filed an affidavit, but the Revenue Department also adopts the same stand has been taken by the district administration. And as such, as the writ petition is devoid of any merits, the same is liable to be dismissed. This court have given a due consideration to the respective submissions made by the learned counsels for the parties, and have also perused the materials on record. From the materials on record, it is apparent that the petitioner was allotted a plot of land for a period of 3 years on payment of the rent for establishment of a brick manufacturing industry. Pursuant thereto, an agreement was entered into, wherein it was categorically mentioned that the petitioner was allotted the land for a period of 3 years, and the petitioner had to pay the dead rent or the royalty as may be fixed by the DC oblique the SDO. It is also seen from the perusal of the agreement in question that it is only when the stipulation, the conditions mentioned in the agreement are violated, then the DC oblique the SDO could evict the petitioner forthwith. This court have also taken note of that the clause 11 of the agreement also stipulates that after the period of 3 years being over, the the petitioner had to hand over the possession to the authorities concerned. Be it as it may, even after the expiry in the year 1995, the petitioner continued to remain in possession, and the petitioner also continued to pay the rent, as is evidence from the materials on record. There has been no steps taken for the purpose of cancellation of the rent, a cancellation of the agreement, or for the purpose of or informing the petitioner that the agreement no longer holds the field. What has been done in the instant proceeding is that the circle officer have exercised the powers under Rule 18. That too, without issuance of notice. Full stop. It is true that the land in question apparently is a VGR land, which, as per the land policy, is not capable of being settled without the land being de-reserved. Full stop. Be that as it may, the question, however, arises that if there is an agreement on the basis of which the petitioner have already entered and have set up an establishment, unless and until the said agreement is not cancelled and steps are being not taken in accordance with the provisions of law for eviction, it is the opinion of this court that the summary mode by which the circle officer have taken steps for the purpose of eviction of the petitioner under Rule 18 is not envisaged, more so when there is a bona fide claim of right involved in the instant proceedings. Accordingly, this petition stands allowed thereby by setting aside and quashing the impugned notice dated in notice to sale, notice dated so and so, notice dated so and so, and notice dated. Before parting with the record, this court, however, observes that the instant observations made so herein above would not preclude the state government to take appropriate action as envisaged under law. Separately, huh? Yes, Mr. DJ Das, you are not there in the matter, but help him with the dates. Yes, Mr. Counsel, let him get some solace in one dismissal now. You don't have an agreement.
No agreement, my lord, but there is, your lordship kindly page 30, my lord. It has been specifically allotted, my lord, in the name.
Page
30.
I see it. This is absolutely illegal. But have you mentioned, Mr. I tell you one thing. If you have made an allotment, maybe for a period of 3 years, how can you, without cancelling this, saying that you don't have any right out here?
It's one time.
Understood. But there is an allotment. You allowed him to enter. He constructed. He has been paying the dead rent or whatever may be. Then how do you take care of it?
So we can have 18
18 for what?
regarding the eviction.
Understood. But don't you have to cancel this? That the allotment which was given, why the authorities are not taking up? Why the revenue authorities are not taking up this issue? The revenue have granted the allotment to him. As per the land policy, what is given?
By the revenue department, those agreements were there.
This is for government cast land. Why have you given this? See, government cast land for manufacturing. This is for government cast land. So how are you giving DGR lands? How are you doing it? What are you set up?
My lord, your lordship may consider page 37, my lord, the period has been extended.
Huh?
Enhancement of the lease period of the government land allotted for this many hectares.
Mr. Council, don't come up with this type of submissions later on. This is by a pollution control. And they, are you saying that they are extending that one?
Page 13.
Hmm.
Starting with allotment.
Hmm.
Person, lordship, there are three agreements which your lordship has performed on the order. Three agreements. Well, without there being an agreement with the present petitioner, can be treated as an enforcer. And because there is no such any agreement with it. With the present petitioner. There being an agreement, lordship, matter would have been different. You to allow with this, the other three cases.
Hello.
My lord, regularly revenue has also been collected by the department from us, my lord.
Bedokoli Joromena is different from payment of the others did not pay that Bedokoli thing. They paid dead rent.
After expiry of that term of 3 years, the rent which they are giving, that is paid upon the lordship. But that cannot be lordship in the other case. But in this case, lordship, yes, that's because.
Finally come to G2, annexure G2, page 48 of his petition. Huh?
Present value.
Yes. পত্তাদাৰৰ নাম DND ইত্যাদিৰ নাম কাৰ পৰা পোৱা হ'ল ইমান কোনভাবে জমা হ'ল এইটো নিৰ্বাই গিয়া বেদখল Finally come to this one, page 50. Revenue royalty for 2016-17. Well, why you are accepting? Why have you not taken any action? No. We have it some other day. Okay. Revenue, what is your stand? You have done the mischief. Mischief is by you. Why on earth did you give the VGR land? Why you have given a VGR land? And have you entered into agreement with them or not? Please this matter again on 18th of November 2024, on which date both Mr. H. Sharma and Mr. A. Bhattacharjee, appearing on behalf of the District Administration and the Revenue Authority, Revenue Department, shall apprise this court as to whether there is any agreement entered into between the petitioner as well as the respondents. So, in term of the personal, you should continue to that. As to whether there was at all any board's resolution to see whether the chairman was authorized, or there was any board's resolution to the effect whereby the board have given the immunity. Hmm? Huh? Understood everything, but you see, we are to hold one thing, that the chairman did not take the board's concurrence. And in view of that, 64 is violated. 64, no? Is violated. And as such, it is not binding on the board. So for that, we require as to see as to whether the boards, was there any minutes to the effect, thereby authorizing the chairman, because this is to be done by the board. And if it is to be done by the board, 37 says that the chairman can do only upon being authorized by the board. The matter upon being heard at length, this court is of the opinion that for an effectual adjudication, the minutes of the board's meeting, the minute book, it is kept in a book of the resolutions of the board during the period when the petitioner in WPC number 2407 of 2020 was initially was purportedly granted, purportedly allotted, is required to be looked into. Mr. So-and-so appearing on behalf of the Sapor na? What is that? Sapor. Sapor. Yeah, the municipal board is directed to produce the minute book of that period to ascertain as to whether there exists any board's authorization to the chairman to make settlement, allotment as has been done in the instant case. As has been purportedly done in the instant. List this matter, how much? List this matter again on 13 November, but today is what? 6th, no? We have it on 18th November. 19th is Tuesday. Matter won't take much time. 20.
Item 18.
Please, man. Allotting this matter, Senior Mr. SP Chaudhary was appearing. Now the brief has been withdrawn from us.
Obviously. What is the admission will be of the, what are you challenging? Challenging? Allowing the petitioner to extract the balanced quantity of stone materials by taking into the representation submitted by the petitioner in view of the judgment dated and after hearing. So the petitioner have lost hope. Either with the council or with the court. Which one? Either of it. These will become infructuous. Balance quantity remains. How can now how can this court now permit balance quantity? Where is that order passed by this court? 7/1/2020. You were given the permission to do for what time? Collection of stones. And when did he take the file from you?
Long back ago, he took us the file.
Huh?
Long back ago only he took the file, but since it appears that none has appeared and our senior's name was reflected, that's why my lord I am here.
But for doing so, you require how can you extract now? So there are two ways by which either by way of a mining permit which is being given under section 5, rule 5, right? Rule 5, or by rule 8, or this is send, it is not send. So rule 13 or 14 won't come into picture. So this is stones. So under it has to be done under 5 and 13. But why was that not pointed out in 2020? This was given at that point of time, 2003, isn't it? Huh?
The one part.
This is what he is asking. He's asking that is one. See his prayer. He is the petitioner number 3, na, in this matter. Heard, Mr.
K. Vishwakarma. K. Vishwakarma.
K. Vishwakarma, the learned counsel appearing on behalf of the petitioner. Mr. I. Bottakur appears on behalf of the respondent. So Mr. K. Vishwakarma submits that he is no longer holding the brief and the file have been long back taken by the petitioners with an undertaking to engage some other counsel. So, be that as it may, Mr. I. Bottakur, the learned counsel appearing on behalf of the forest department submitted that that the prayer which have been made in the petition cannot be granted now, taking into account the Assam Minor Minerals Concession Rules 2003, 13, which have been made by the state government. This court have also perused the said rules and is of the opinion that without there being a mining permit, in terms with Rule 8. Rule 8, na? 5 is for contractor. We are not concerned. I think Rule 8. With Rule 8, there cannot be a question of permitting the petitioner to extract any quantity of stone materials from the Lasisera Nala. Accordingly, the instant petition stands dismissed. Be that as it may, the petitioner, if so aggrieved, may be at liberty to submit a representation if there is any amount to which the petitioner is entitled to for the unextracted quantity of materials lying with the forest department. State.
Senior's name may be reflected in the speech of this. On behalf
I
of
reflect today senior's name, tomorrow senior is somewhere in Spain. Then, how do we know?
Outlet.
19. 16 and 17, Lordship has fixed it on 20th. My lord, I will not be available on 22nd.
Fantastic. Won't be there.
My lord, can it be on 22nd, lord?
No. 20. Do it through video conference.
18 by.
No, we have fixed it on something, 20. Do through video conferencing. Now we are in a very technological era.
19.
You're filing affidavit. So and so. What is this? So many matters.
Regarding, my lord, second class fishery, my lord.
Include
of names
order
of the-
dated demand passed in second fishery case by the settlement, including the names of Iman without considering the objection filed by Swell. What? Inclusion of what?
Inclusion of name of the private respondents, my lord.
As
Allotting, my lord. Since we have been allotted, my lord, the fishery, my lord, subsequently their names again included, my lord, another 42 persons have been included, my lord.
are
It is
service
a small
complete
fishery
upon the
matter.
private respondent? You have filed your affidavit. Okay, the council appearing on behalf of the respondent submits the 3 weeks time may be granted for filing the affidavit. This matter again on 11th of December 2024. The affidavits by filed by the respondents by 6th of December.
Okay.
20.
So what has happened now? No, what is this impugn notification for? Hmm? Why is he challenging that? The further issue is directing the removal of overhead lines along the properties of the yard. So you have done so without, have you taken any action against the petitioner? Is your line over the area of the petitioner? Huh? What is your stand? Let us see your stand. Hmm? I have seen it. Now you've completed the work. It's completed. Because as per the affidavit, it is 90%. Now it has been completed. So the petitioner, if he has to seek for compensation. None appears on behalf of the petitioner on call. Mr. N.C. Das, the Lily Senior Counsel, assisted by so-and-so, appears on behalf of the Power Grid Corporation of India. Respond number 2 and 3. The learned counsel appearing or senior counsel appearing on behalf of the respondent number 2 and 3 submits that as the work in question has already been completed, the petitioner is aggrieved, the petitioner can only resort to seeking compensation in terms with the provisions of the rule, section 11 of the Indian Telegraph Act 1882. Taking into account the above. 1885. Taking into account the above, it is taking into account the above and also upon perusal of the materials of the court, including the stand taken by the respondents in the affidavit. This court is of the opinion that if the petitioner is aggrieved by the acquisition, the petitioner would be entitled acquisition and the violation to the rights under violation of his rights under Article 300A of the Constitution, the petitioner can take due recourse under the provisions of Section 11 of the Indian Telegraph Act 1885. With the above observations and discussions, the instant petition stands closed. You take this.
Item 22.
So are you evicting the petitioner? Yes, respondent, what is your stand? Miss N. Bodley, appearing on behalf of the Revenue Department, submits that she has received certain instructions in the matter. She therefore submits that she would like to bring on record the instructions by way of an affidavit. This matter again on 2nd of December 2024. In the meantime, the affidavit will be filed by the Revenue Department.
23 and 24.
Any decision by committee?
And that committee
Yes. Yes? A new committee has been constituted, and when it is fixed, it has been submitted by Mr. J. Sutiu that pursuant to the order passed by the court, a new committee has already been constituted and the meeting is to be held on 12/11/2024. Taking into account above, list this matter on 25/11/2024, on which day the council appearing on behalf of the Karbi Anglong Autonomous Council shall provide an update.
Item 25.
Oh, Mr. Talukdar is the person who is in urgency in this matter, na? Why you are not asking these people to quickly do it? Isn't it that the road? Yes. How much road construction has been done there? No, I'm asking from Dokmakwa to Dimapur. Manja to? Hmm. But the construction is going on there. So from Longley to this place, Dimapur, how much construction has, how much is remaining? Oh, that, what has happened to that? Manja to Numuligal? And Manja to the other side, the number. No, what about the road from Manja? You take a left and go towards the other road, which goes to Numuligal. That road was there, but the construction that road is closed now. But there is no stay here. So you mean to say from this area comes from, what about the forest area which is there? That is absolutely a reserve forest. There's no people out there. So it was reserved and de-reserved under which provision?
The Indian
Forest regulation. So should we give an earlier date in this matter? If I fix it on 25, when should I give it? No, should I give an earlier date?
Yes, they have the earlier,
That is why I'm saying. no? No, then let us have this on 12th. No, let us have it on 18th. 18th, you give an update what has happened. Thereupon, I think we can. I think something will have because otherwise, Mr. Bora is only anxious with the compensation. He has to get a compensation. He has a problem as regards not the question of compensation. The problem is this is delaying the project, and this is also leading to escalation of the price. So that is another issue. So, if you bring it to the notice, and then if there is a joint verification required, then I'll give again a time for that.
Lordship, as per the guidelines, Lordship, there are two stages of approval before they can start work. As per the papers, Lordship, they have only received stage one approval. So before starting work in that area, they have to receive stage two approval also from the competent authority.
How are you concerned? You want compensation?
Yes.
18 go delivery. Next. Yes, what is this? Another matter? 7-9, this Chandra Bay.
Land of the petitioner has been taken away, my lord, without.
You are there.
Yes, ma'am.
You are there in this matter.
By the NSN issue for eviction of those persons for in the right of them.
This is nothing to do with KAC, but you are doing it under that, there's a rule, na? Then what are you doing there?
The land of the petitioner, my lord.
Huh?
Part land of the petitioner has been taken, no compensation has been paid, my lord. Affidavit filed by the, my lord, National Highway Authority, my lord, they said they have paid the amount to the Tribunal Autonomous Council, my lord. There are three, my lord.
Three. The notice has been issued by whom? Where? But in paragraph number 5, you say that the petitioner is praying for setting aside and quashing the impugn notice dated so and so notified by the principal secretary KAC
That is the notification, my lord.
and removal of unauthorized occupation issued by the respond number 8. Respond number 8 is you. In this way, the answering the roadside reservation of the land in respect of area under the jurisdiction of Now, has the land of the petitioner been acquired? Huh? That is not clear.
Yes.
Huh? Yeah. The authority of Karbi Anglong is pleased to notify that henceforth roadside reservation of land in respect of area under jurisdiction will be 50 feet on either side of the road from the center of the existing road from so and so to Lahore. Now, this is understood. There's no problem with that. But the question is, have you acquired that land? In the meaning of the roadside reservation, if you don't acquire the land, but you just take over and don't pay, can you exercise this jurisdiction? You can't do that. Is it?
My lord,
As per our budget, Costa budget, 25, and our commission of Costa itself, without paying compensation for them, but the land can be for. Fine. So, my lord, because they are, that's what is.
One is of Mr. Ken Chaudhary. That where the six are there, na? Huh? So the number one has now the. Okay. It's listed today here. Okay.
Regarding whether they are the compensation or the compensation, if they are not, and that will be the land compensation, whether they are.
But that is one thing. But the second aspect of the matter is, just for example, today it is not 50 meters. He is enjoying his land. Tomorrow you acquire land, putting it here, the land is here now. Now you put the land till there. And then from there it is 50 meters.
Here, is the concept. However, it's the concept, right, and that if the computer cannot construct any permanent structure, we will see it from the edge of the alignment. They have not seen the concept.
That is one thing. But the fact that his ownership of the land can it be? So therefore, how can you take his land and issue a notice to him?
Under the, majority is the right of way. And that's why it is the right of way, but they cannot.
No, thereby you are making that the right of way, you are taking away his right of way. Okay? Of this is which place? Manja? Huh? Ah, this looks like Manja area.
Already demolished, my lord. Demolished, compensation part is there.
But have you got the compensation?
No, my lord.
Why?
They have not paid, my lord.
Like, is your name included in the 3D notification?
Hmm.
Then if it is not there, then how are you taking away his right? Understood, but by way of means right of way means you are giving the right of way to everybody. That can't be so. Okay, you are enjoying a stay.
No, my lord. Already demolished, not taken away.
Now what do you want?
Land has been taken away.
So what do you want now?
Compensation, my lord.
So your
compensation part is
first
there.
prayer is gone,
One
the
month.
second prayer. And you have challenged that notification of whose? 2310?
That is in the affidavit, my lord. Page 32, my lord. The petition is not there, my lord.
So you are challenging this notification. Okay. Hello. Anyway, Mr. J. Sutia, the learned counsel appearing on behalf of the petitioner submits Kabi Anglong Autonomous Council submits that he would like to file an affidavit in the matter. To list this matter again on 4th of December. In the meantime, the affidavit be filed by the Kabi Anglong Autonomous Council. In the meantime, additionally, the petitioner would also be at liberty to file the reply to the affidavit filed by the NHI DCL.
26.
Wait, please.
Yeah, what is this?
My lord, 24 number of petitioners have filed this instant writ petition, being agreed by the fact that their patta land has been taken over by the government for constructing a model degree college without there being any acquisition by legal means. So initially,
What do you mean by legal means?
by adopting any of the land acquisition, it was not acquired by the government. In fact, what had happened, pursuant to filing of the writ petition, the government had filed an affidavit. In that affidavit, it was projected that out of the 24 numbers of petitioners, 14 number of petitioners have relinquished their land by way of a, if I may say so, a relinquishment deed, which is called istafa. Which is called istafa, and in fact, they have appended the relinquishment deeds along with the affidavit in opposition. Now, in similar cases, there was a similar batch of writ petitions which was disposed of by this honorable court, wherein the honorable court had held that since there were complicated questions of law, this court cannot entertain, and so the matter was dismissed. But however, we stand on a different footing for two reasons. The first, the respondent themselves have admitted that out of 24, only 14 petitioners have relinquished their patta land. Even assuming,
Show me that order which was dismissed.
yes, it's them. It's an order authored by Honorable Justice Manish Chaudhary.
Because my view is different. My view is
Yes,
different.
there are
That is
additional
why
points also, how it is different. This matter is also different. Not on really distinguished. The operative portion starts from paragraph 23.
Oh, this is a different aspect. Because here, there was an allegation that, yes, they have signed it, but there was an act of forgery.
Forgery. Yes.
Is why.
Our contention is, my lord,
But if your land is being taken away and there is a violation of Article 300A, then it is the writ.
now, my contention is, the first contention, even assuming, that istafa or that relinquishment deed is valid, it would only operate for the 14 petitioners, the rest 10 petitioners, even the government says, there is no relinquishment deed. That's the first point. The second point, my lord is aware, a relinquishment deed would fall under the ambit of section 17(1)(b) of the Registration Act. Now, if it is a relinquishment deed and if it falls under the ambit of 17(1)(b), in terms of section 49, it has to be necessarily registered. Now, it is not registered, that's admitted, it's not registered. Now, what is the effect of non-registration, In my humble submission, the istafas or the relinquishment deeds are not registered. First of all, they cannot be brought or considered as evidence, like they have pended in the opposition. That cannot be considered at all since it is not registered. Secondly, I've got doubts, without there being a registered relinquishment, because after all, it's a transfer of property, So will the title change hands? Even assuming that we had signed the relinquishment deed.
So the
These
title
issues
can
fall for
only
my-
change on the basis of some law, either by law or vested by law.
Right.
There has to be a conveyance in accordance with law.
But I have to admit, the land revenue regulation speaks about relinquishment. The provision is there, but it does not say that it will be notwithstanding the provisions contained in the Registration Act or
What does it say, land revenue?
My lord, takes up the judgment that has been quoted in the judgment.
Yes.
My lords comes to paragraph 12, my lords. May I read it? Chapter 2 of the Assam Land and Revenue Regulation 1886 has defined the rights of different class of persons recognized by the regulation 1886. And there are mainly three classes: proprietors, landholders, settlement holders. Other than landholders, including persons holding lands directly under the government, under annual leases, etc. Chapter 2 provides for issue of settlement rules. My lord may skip this paragraph. My lord may directly come to paragraph 13. Section 10 and 34 of the regulation 1886 have provided as under: any landholder who, after the commencement of this regulation, voluntarily relinquishes any land and ceases to pay revenue assessed thereon, shall at once forfeit his status of landholder in respect of that land. Now, 10 speaks about a landholder, my lord. 34, effect of acceptance of settlement. When a settlement has been accepted, the revenue fixed thereby and no more shall be payable from such date and for such term as the state government may fix in this behalf, provided, my lords, D is important, which is relevant, my lords, provided in any local area to which the state government may by notification apply this clause, a settlement holder may, after giving notice at the time and in the manner prescribed, relinquish the estate of which he accepted a settlement or any part thereof on which a separate part of revenue has been apportioned, and shall thereupon be released from all future obligations to pay revenue of the estate or the part thereof so apportioned as the case.
Yes, Mr. Majumdar. Voluntary relinquishment, very well. Relinquishment has to be as per law. No, if there is a relinquishment, the relinquishment has to be as per law. You see, 34 is a case of effect of, one has to understand the 1886 Act in a sense that payment of land revenue was also an issue at that point of time. We see those lot of agrarian revolutions to the effect that the people are more concerned of paying this land revenue. Now those land revenue has become peanuts unless the government of Assam increases. It should increase it, taking into account the value of the land. That's a different aspect. But the thing is, therefore, the question of thinking, for a person we are going to offer you a settlement, you may refuse also. Things which are not conceived of now. I mean, these are practically not there. But anyway, if it is a relinquishment of a right of a property, how do you take care of? Section 17 and 49. Mr. Majumdar, would you like your land to be taken for the purpose of construction of the bridge? Because after all, Mr. Majumdar will be using the bridge tomorrow for coming to the port. I'm asking. Yes. If it says relinquishment, yes, relinquishment has to be as per law. But you may argue one thing. Relinquishment does not confer rights. Does not create right. If it does not create right, where is the question of registration?
I was not told.
In cases where there was a new construction, if you was when a party came in, the time complete in those but in other cases, integration paper is pending. The evidence have been taken time. Back in which it then it a order passed with the pendency to be in the case passed an order then initially when before that now it's going even when it's effort
In the writ appeal.
effort to the purpose of giving the
But this is pertaining to those who have given relinquishment. But here 10 is not. No, 10 have not.
Out of 24, only 14, according to the government, that we have relinquished by way of those istafas, by giving our thumb impression.
He says 10 are not.
My lord, because I think
given
it has to be tallied with the my lord, relinquishment deeds. And insofar as Honorable Justice Chaudhary's judgment is concerned, my lord, this point was never raised that it has to be registrable. After all, it's a transfer, my lord. Pattalan has been
No. Therefore, I'm saying.
Yes.
See, there is a difference between transfer and a release and a relinquishment. By way of a release or a relinquishment, or more particularly a relinquishment, you give up your right. But you don't give up your right in favor of anybody.
But my lord,
Oh, no, that is what I'm saying. You don't give up your right in favor of anybody, because the moment you do it in favor of anybody, it amounts to a transfer.
with the deepest respect, my lord, this issue has been settled by the Supreme Court, my lord, Honorable
Yeah.
Justice Gogoi, my lord, where similar things cropped up, my lord. There was a partition deed, my lord, and in that partition deed, a suit was pending where there were two exhibits, and those exhibits were that of a relinquishment by one of the family members, my lord. It was held, my lords, that the relinquishment deed, since it is not registered, the court had held it is necessarily compulsorily registrable and it should not be considered.
You have to see the facts of that case wherein it say as to whether by that deed any right has been transferred.
Yes, right.
There's a difference out there.
May I
That is
read
what
out
I'm
the
saying.
judgment, my lords? I have marked the relevant portion.
If in a case of a relinquishment deed by which any right or transfer is there or creation of any right is there, it's okay. Just for example, that is why you see, that might be a one judgment. Take the example of family settlement. Why does Supreme Court time and again say that a family settlement is not required to be registered? Why? Because there is no creation of rights. In that case also, somebody say, okay, they don't take the part A property, but I take the part B property. And the other person says, I take the part B, but I won't claim part A. But there is a relinquishment there also. But the Supreme Court says, no, not necessary to be registered. Why? The reason is because there is no creation of rights in favor of anybody. The moment there is a creation of rights of anything, then it becomes. Here, if we go by 34, here it is, or the clause 10, it says, here is a case where the government, therefore I say, 1886 Act has to be understood in that context. You give a particular plot of land, look here, we are giving you a settlement. Tomorrow that you say that, no, I am fed up with this land, I don't want it. What is the government going to do? Government is going to say that, okay, you are not paying revenue also, nothing is doing. Government will say, okay, happy. I won't do anything. Can't do that. Government has to take the revenue. So that is why it will happen. So that case which you are referring to has to show that if there are in sometimes some relinquishments are made, thereby creation of rights. There are many cases that I relinquish my property out here because I have got all the money out there and thereby I am relinquishing my right. There are many cases, I'll say. There might be very conflicting cases. There are a lot of conflicting cases where there is a person may not have some rights, but he is claiming some rights. Then
Partition. I mean, the pen requiring registration, not requiring.
yes.
It is a memorandum of already partition property. Then
No, a family settlement is not required to be registered, but if it will be required to be registered, just for example, a person has no right at all. But you are creating a right, okay, he had nothing. But if in a 1 bigha of land, 4 persons are having equal rights, one may say that, okay, I'm not taking it. That is a relinquishment. But you're not creating rights in favor of it.
existing right.
Yeah.
The moment a person is settled with land, the title transfers, my lord, if I'm not wrong, my lord. And now, my lord, by way of the relinquishment, that title has again been transferred to the government. my lord. So will it not amount?
No. It is not transferred back to the government. The title remains with the government.
Yes.
That is why you are lessee. But the moment tomorrow, you have to also consider it, take a case of a lessee. You are a lessee. And tomorrow you say that no, I don't want to be there, they take it. I surrender my lease. Is it required to be registered? No. No, sir, you are surrendering your lease. That's it. That is the difference between, therefore, you have three types of land. One is the permanent settlement. Permanent settlement lands which are there, which cannot, under no circumstances, there's no question. The others are periodic leases. Pattas are leases, annual leases. So under such circumstances, these are lease. So the government, you said, okay, I'm forgetting and I don't want the lease.
But, in that case, my lord, I have to satisfy my lords on the aspect that if there's a relinquishment in favor of the government, whether section 17(1) would apply or not, whether it's required to be registered. That's the, I'll try and satisfy. But even in that case, my lord, my first contention always remains, my lord. Insofar as the 10 petitioners are concerned, they have never relinquished their. Yes.
Only, there's no quarrel with that.
Yes.
But therefore, these people are saying this is whatever that the document is by call. But the question is, they say that, okay, I'm not bothered, I don't want this lease, okay, take back whatever you have given me, you take back. You're not creating a right. But the moment you sell it, just for example, there's a sale by government. Oh, he can't relinquish it. No. He can't relinquish in favor of the government. No, I relinquish it. Then the moment, just for example, if you tomorrow you relinquish a property, what happens? The consequences is, isn't it, Mr. 300? 1, 2 article? Doctor, no, not 300. 302. Doctor of HC, doctrine of HC will apply. You relinquish your right. The property then goes back to the state. How do you take care of that? Constitution. Anyways, very debatable questions, not to be dismissed.
I've taken note, man. I'll try and satisfy my.
I keep on learning so much. 300? It's there, no? Okay. What do you want now? What to do?
The pleadings have been exchanged, my lord. Perhaps the matter can be fixed for hearing where
You want to admit this matter?
maybe for admission hearing, my lord.
When, next year? Somebody have given me the 2025 calendar. Let's use it.
Unlike the other petitions, my lord, we don't have a stay order.
Huh? Okay.
Started in 2017.
No, in our case, it started in 2019.
And also 3 years.
19, my lord, the stuffers are dated.
No, when 19 you have given, but when was the land taken? But anyway, if you see the Vidya Devi judgment, question of delay doesn't there. Delay in latches has nothing to do with the constitution. Upon the matter being taken up, and an urgency is being shown by the counsel appearing on behalf of the petitioner, and this matter again on 28/11/2024.
Okay, right.
27.
Both matters. কিমান আছে? Huh? 10D না? সেই আগৰ এই কেছটোত লগাই দিবচোন কোনোবা এটা আছে। তেখেত এপিয়াৰ হৈছে, আদাৰ চাইড ৰেছপণ্ডেণ্ট এপিয়াৰ কৰা নাই, পিটিশ্যনাৰ এপিয়াৰ কৰা নাই। Yes. FCI. Oh, where is this? Yes. It has been submitted by the council appearing on behalf of the FCI that the counter affidavit would be filed by Monday, by 11/11/2024. Full stop. Taking into account the above, list this matter again on 20/11/2024. In the meantime, the petitioner would be at liberty to file the reply. The issue is simple. The plant and machineries are kept, so you want the returns. Yeah.
In this case, my lord, the other side is filing affidavit in opposition, my lord. Other side has already filed an affidavit in opposition, my lord.
You want to file a reply?
Reply, my lord, because but the petitioner mother is expired. So just one if you.
Oh, yes. That is why I asked, what does the petitioner's mother have to do
Yes,
with
because-
filing an affidavit?
My lord, petitioner has to have a reply.
It has been submitted that the respondent number 225 has filed the affidavit in opposition, and the petitioner, on receipt of that, is taking steps for filing the reply. However, unfortunately, the mother of the petitioner has expired, for which the affidavit could not be, affidavit in reply could not be filed. Full list this matter again on 9th of December. In the meantime, the reply be filed by the petitioner.
Thirty.
You received? Now you will be paying it to him. So we have it in the first week of this, the third week of December. This Mr. Mr. Dina, appearing on behalf of the PWD, submits that the financial sanction have already been received. The full stop already been received. Financial sanction dated. What is the date? Have already been received on 25th of October. In that regard, he has placed before this court a document which is kept on record and marked with the letter X. Full stop. He therefore submits that some time would be required now, for the purpose of disbursing. Some formalities are required to be complied with before disbursing it to the petitioner. Full stop. List this matter again on 16th of December for an update.
31.
None appears on behalf of the, who is appearing for the petitioner? None. Withdrawing? What is the matter?
Here, my lord, the petitioner getting, they have passed out, my lord, diploma in pharmacy. They have demanded that, my lord, they have not been registered in the Assam Pharmacy. However, my lord, contested in the affidavit is stated, my lord, they have passed out the class 12 standard from, my lord, under to education.
Under?
Education. There's a study center in Nogam, so there they, that, my lord, now, my lord, there is a notification of the central government stating that, my lord, that Urdu education board has no authority to issue such, my lord, past certificate. Now, my lord, that issue is pending for the Delhi High. And, my lord, presently I take the status. Matter last came on, my lord, September 2023, 24. And matter has been posted sometime in January 25.
So we should decide prior to that.
I just informed.
No, we should decide prior to that.
No, that particular matter notification of the central government is not under challenge here.
Then here they want that they should be given registration under section 32.
Provisionally can be given, so subject to outcome of the, so if that notification is interfered with, then my lord, their certificate of 12 standard will be null and void. It has been already mentioned in the notification.
And how many petitioners are here? They passed class 12. In which?
From a study center in Nogam, and my lord, that certificate has been issued by the Urdu Education Board.
Urdu Education Board. What does Urdu Education Board have to do? With Urdu, it is okay, but what about and none has a single subject of Urdu? Huh? Hindi, English, maths, science, physics, chemistry, and biology. And it is the Urdu Education Board. So this, and because of this, as per you, thereafter they did the Polytechnic.
Not politics.
Okay, diploma in pharmacy, they have done it. Now you are not giving because of that Urdu.
By the pharmacy council, I think that my lord, know that notification has been issued by the central government. If that has been particular para of that particular notification has been stayed by the Delhi High Court. Page 90.
Okay, I think we should wait. Okay. Because anyway, these people can't be Now, has the central government, the central, who has issued this, the central government? Where?
Ministry of Human Resource Development, Department of School Education and
Clarified by the Ministry in one Department of School Education in one that Urdu education has only been granted to serve minor education, not a minor education board. Oh, that is why they are saying you can't go for physics, chemistry.
but my lord, Union of India otherwise is not a party.
Okay, these people need to be. Okay, none has appeared on behalf of the petitioner on call. However, it has been submitted by Mr. B. Gugoi, the learned counsel appearing on behalf of the petitioner, that this matter would take some more, that certain further instructions would be required, taking into account the pendency of the petition before the Delhi High Court. So, in that view of the matter, list this matter again on 8th of January 2025.
32. This is excise matter, my lord. The lordship has already this there's a decision of the landed single judge, my lord. May I pray, my lord, 1 week time will be granted to bring something on record, my lord.
What?
Unsellable, with regard to unsellable spirit, my lord, which is taxable, the landed single judge held. So, my lord, I want to bring, there was a second time verification and the report has come, my lord.
So,
I want to file the affidavit, my lord. Just,
the judgment is covered, no?
but that is with regard to beer, my lord. Only the beer.
So does it make it non-alcohol?
Itself,
Ah,
my lord.
let us
But
also be enlightened.
let it come on the next week, my lord. I will file an affidavit, lordship will decide. 1 week time, my lord.
Yeah, he destroyed it.
No. There is a verification.
Huh?
No, not destroyed, my lord. He is asking for destroyed. That is not taken place, my lord.
Now what do you want?
I want to bring some documents on record, my lord, next week, by any day, my lord.
I gave you last time.
Last time, my lordship,
I gave it to you on
Vacate the-
29th. I gave you again on
lordship
18/9.
has vacated the order, my lord. Of course, there is nothing on the vacation. 1 week, my lord.
Has he
Nothing.
paid that amount?
Yes, order is vacated 29/8, lord.
Yes. At the request of Mr. J. Roy, the learned senior counsel appearing on behalf of the petitioner matters St. John, as he wants to bring certain documents on record, list this matter. You got the money?
We are paying, my lord, also in installment 1 crore. We have already paid, my lord.
List this matter again on 21/2025. The pendency of the petition shall not debar the state, the department to take steps for the purpose of recovery of the dues.
And 34.
Yes, what is this?
Your lordship, my lord, kindly see the previous order. The petitioner has already taken the brief from us, my lord, to engage in new set of counsel.
Is appointed with you.
Step up from this case.
What?
Petitioner has already taken the brief from us. As per the previous order.
Yes, we are paying for the. Are these petitioners entitled to the what they are asking for? Petitioners are asking that they should be provided this and NREGA. Yes. Provide jobs and unemployment allowances to the petitioner and the. What is this read for that? Yes, tell me, what is your petition reply? So they want some job. What are you to do? So are we to accept that the NREGA has gone, you are not following NREGA any further? Who is appearing for the central government? Is the central government the party? Yes, who is appearing for the union? Yes, why? Ms. Gayan, does the has the central government given up NREGA? File your affidavit. The central government is directed to file the affidavit in the matter as to whether the scheme provided for job and unemployment allowances under the Mahatma Gandhi National Rural Employment Guarantee Act 2005 is still in force. It is still being continued by the union, still being continued. Let's list this matter again on 24th of January 2024. Yes, madam, you appear in this matter alone. Forget about the others. You start appearing.
File.
Take one copy from me.
Taken it from.
Take one copy from here. You appear next time. Not your senior. Get a chance to appear, you appear. Yes, what is this? It will be us
35.
amount of delay for conducting the event prestigious round so have not been given to the Yes. Any stand? No stand. Social welfare? Has he got the money? I think so. Why the petitioner is not representing? Just inquire. This matter again on 2024, on which date Mr. K. Gogoi shall inquire as to whether the petitioner herein have been paid the dues as claimed in the petition.
6.
None is appearing very well. Mr. BJ Taluk, oh, here the problem arises. Is it by state of Assam? No. Who is appearing? Affidavit filed. Hello? Mr. Ahmed, does he have any case? In the yesterday's order, I have just added one line that the PD as the matter pertaining to the debit note was pending, the period during the pendency of the writ petition be excluded as regards the limitation. Because otherwise it's gone for a 6. I used that word. Yes, what is this? But this will come within the ambit of a dispute. None appears on behalf of the petitioner on call. Mr. M.J. Ahmed, the learned senior counsel, assisted by Mr. So-and-so, appears on behalf of the respondent numbers 1 to 3, and Mr. K. Gogoi, the learned central government counsel, appears on behalf of the respondent number 4. Pusto. The petitioner herein is aggrieved by the issuance of the show cause. By issuance of the sale invoice dated 14/3/2023, whereby the petitioner which one is the sale invoice? Page 32. Dated one dated. Where will be? Invoice dated 14/3/2023, whereby the petitioner was informed that the petitioner has to pay an amount of rupees 457,042,35.94. It is the case of the petitioner that the amount so mentioned in the said invoice has been wrongly reflected in as much as the amount which the petitioner had lifted is 2835 metric tons, whereas the sale invoice mentions about 3970 metric tons. Full stop. This court, however, has taken note of that the said purchase so made by the petitioner is in terms with the Spot E-Auction Scheme 2007, which categorically stipulates that if there is a dispute, which categorically stipulates in clause 11.12 that if there is a dispute, the same is arbitrable. The fact as to whether the petitioner had lifted 2835 metric tons and not 3970 metric tons are questions of facts which cannot be decided in a proceedings. Taking into account that these are disputes, the petitioner would be well advised to approach to initiate proceedings in terms with clause 11.12 of the Spot E-Auction Scheme 2007. Accordingly, this court is not inclined to exercise the writ petition, the instant writ petition, on the ground of availability of an alternative and efficacious remedy. Be that as it may, this court, before parting with the record, this court further observes that the dismissal of the instant writ petition observe that the instant writ petition has been dismissed on the ground of availability of an alternative and efficacious remedy. And as such, the observations made herein above shall not cause any prejudice in any proceedings initiated in terms of clause 11.12 of the E-Auction Scheme 2000, Spot E-Auction Scheme 2007, with the above the petitions disposed. Interim orders, if any instance vacated.
37.
Wait, please, your lordship. Lordship, this matter pertains to a demarcation of a plot of land, lordship. On the last occasion, Lordship,
I've asked you to file an additional affidavit.
additional affidavit. Lordship, there was a miscommunication with the petitioners. They are only concerned with the 2.15, 2.15 lessons of the plot of land for the demarcation, Lordship. They are not.
Oh, yes, yes.
That-
I mean, are given the liberty to file an affidavit bringing on record any document of title. Oh, so he's only wants 2/15 lectures.
Yes, yes.
Where's the other side? There was another person who was fighting. There was another person, huh? The respondent?
Respond number. Private nothing, this side, this one.
Somebody else is in possession.
No, Lordship.
Oh, these are two brothers.
Two brothers, yes, Lordship. They
I
filed,
see,
we have
I
filed
remember.
a affidavit by the.
Because it was rejected, the earlier brother did not give the consent.
Yes, Lordship.
Sure.
After that, we have filed a petition.
List the matter on Friday. Or Tuesday, Friday, at the top of the list. Dispose it of them.
Much obliged.
Matter being heard at length, the matter will be listed on Friday at the top of the list. Yes. Oh. Nobody will appear in this type of matters. এটা যে কেসও আমার অর্ডারটা হয়নি মানে এটা মহিলা অ্যাক্সিডেন্ট হয়ে যায় এখানে গাড়ী নম্বৰ থকা এক্সিডেন্টটো যে হলে যে ডিসমিস করো কেয়ার সুলানা সব অর্ডারটো লৈ Petition dismissed. This may pass the same order, where the vehicle is identified, so we dismiss it. Taking into account Justice Surana's order. Has it been set aside by the division bench? Set aside? Ready? Oh,
Lordship will kindly see, page 20.
allotment of a particular, the request has not been acted upon. You are seeking, you have filed your application?
Yes, page 20, my lord.
And how?
Now, first, my lord, page 16. My lord,
No, how are you filing this type of application?
page 16, Lordship, kindly see. Page 16. This is online.
Application
nothing.
done.
Yes.
Then
again, page, my lord, 20,
then
but no response is given.
yes, revenue department. It is
my
for the
deputy-
revenue and why you are not taking any action?
Deputy Pyramid, let the deputy commissioner be directed to consider my application as reflected in the.
Mr. M.U. Mondal, if you want such types of orders, then I think I should say it not before me. If you have to get it, you'll get it. Otherwise, don't get it. Why should I say that, okay, consider? I'll ask them to consider when it is necessary.
Since
Let us see
22
why.
Matter is pending. my lord.
Eh?
Since 2022.
Don't worry. The matter has come before me, so it will take it. Bring a record, get your instructions. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in disposing of its request for settlement of land. It is seen that the petition, the applications were filed as back as in the year 2020. 22. And there has been no steps, and it is alleged that no steps in that regard has been taken. Good stop. It is also seen that this court had issued notice as far back as on 28/5/2023, but there is no instructions. Miss M. Borman, the learned counsel appearing on behalf of the district administration. Hubli. And Mr. R. Borbudari appearing on behalf of the revenue department shall obtain instructions in the matter. List this matter again on 22nd of November.
Obligation.
Yes, yes, council, serve extra copies 1122.
40.
Yes, what is this? Service complete, leave the matter for admission. What is this?
Of the cooperative societies. Challenge to the election of the board of directors of the cooperative society.
Then,
There is a violation to section 37 and 40, Lordship.
okay.
Lordship, the directors are the also
Hello,
the-
we have it on some other day?
Please.
You have your materials?
Even if I have already filed 8 to 10 different cases.
Yeah. Mr. S.K. Talukdar Learned Council appearing on behalf of the Corporation Department submits that the Corporation Department would be filing an affidavit in this matter. It's very far off. That is what I'm giving you. List this matter again on 29th of November. The affidavit will be filed by 27th of November.
Deeply obliged.
One. 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 Yeah, what is this?
Alert, in this case, in the morning, my line friend.
Oh, you want to file? Now you are free, I hope. Eh? Because of you, I had to go very slow in the court so that I don't reach the matter before other courts rise. Yes. You want to file a reply? Why haven't you filed this? What is he asking for?
My lord, in this case, for the notifications have put to challenge. What has happened, my lord? Those have been the private respondents have been made the members of the board, SC board, my lord, welfare board. They are not actually belonging to the ST place community.
Huh?
They are not belonging to the STP community, my lord. In respect of Kachar district, only the Bormons in Kachar district, they are the scheduled tribe, plain tribe, my lord. To
So
become,
they have been given ST certificate.
yeah, those are.
Who are you?
We are the, my lord, Nikhil Kachar,
Nikhil Kasar?
Hirambo Burman, Somiki, and two others. They are the,
Are you ST?
yes, STP,
You're STP?
yes. As per schedule, my-
All of you?
yes, yeah.
And now you are therefore challenging that you given to this Kamai, Rongmei, that they are not STP. They are STH.
They are not STH even in respect of Kachar district. If they are resident of Kachar district, they cannot avail the quota of my lord, STH or STP, my lord. Because as per schedule, my lord, it has to be resident, he has to be resident of.
Who is appearing for them? Huh? You can appear for 7. Understood. She is appearing for 7, that is the secretary, all Assam tribal. Then 8, who is a private respondent. How is it possible? Wouldn't there be a conflict? You can't appear for all these people together. Then it will show that both of you are in hand in glove. And therefore you are issuing this type of notice or you want to prove it. That you are both in hand in glove. Who is paying for 8 to, 8 to 14? Yes, because they are the persons who have given it. Ah. Service as regards 8 not prepared. Fine. Yes. What about the service upon 8 to 15?
As per Loazama, my lord, it is complete.
No, their rights should be taken away. Somebody has to, you can't go by this.
We have taken,
Simple deemed
times-
service aspect is not proper, na?
We have taken 2 times steps, my lord.
And I have also stated, oh, this is not
Yes.
before. The service must be being complete, leaves the matter on admission. The notice have been delivered in the address so and so. Okay, he is there to protect. Okay, Mr. Huh? Mr. Ardhor, the Learned Council appearing on behalf of the, which one? Plain tribes?
Plain tribes.
Plain Tribes Department of the Government of Assam submits that 2 weeks' time is required for filing the affidavit. List this matter again on 2nd of December. In the meantime, the affidavit be filed by 29th of November. Madam, you think about it.
42.
Huh? Direct contract. Yes, who is appearing here?
May I please, Your Lordship? Your Lordship, on the last occasion, we have taken steps, Your Lordship, we have served them the copy.
Where is Mr. H. Sharma gone? Whether he would be in a position to accept notice on behalf of respondent, he submits that he would. Not so. Then what is there? Service is complete, so list the matter after puja vacations. What is your case?
Your Lordship, we have not been provided with the information, Your Lordship. We have also prepared an appeal before the State Chief Information Commissioner. And Your Lordship, we have also made applications to the respondent number 7, 8, 9, and 10. However, no such information has been furnished.
Then
If Your Lordship peruses our main grievance,
have you gone to the State State Chief Information Commissioner?
yes, Your Lordship, we have made an application.
And then also he's not providing.
Yes, Your Lordship, till now, as per the instruction, we have not
Yes.
received any.
Who is appearing for the government in instruction? Who is appearing? Because he's appearing for respondent number 3. Get your instructions in the matter. There's no instructions from any of them. And Panchayat, madam, you were there. Get your instructions. No, Mr. H. Sharma accept notice on behalf of respondent number 3. And I specifically asked, yes, he said yes. Okay. List this matter again on 27th of November 2024. Both the councils appearing on behalf of the respondent number 2, 3, 4. Appearing on behalf of the district administration, as well as the councils appearing on behalf of the respondent authorities are directed to obtain the instructions in the matter. I don't want to file affidavit. Get your instructions without fail. You're Jal Shakti? Okay. You have received the funds? Why? Total amount of fund released on the years of utilization towards the court cases. And so, however, the audited statement of availability is saying that the total audited amount is the month and less amount disallowed is for the concerns of the compliance of the observation of the auditor general. So what to do? We are not concerned. You have got the works done, you have to pay. You file your affidavit. Isn't it? Ms. Again, the council submits that she has received some instructions and she will be filing the affidavit on behalf of the Ministry of Jal Shakti. List the matter again on 22nd of November. In the meantime, the affidavit will be filed.
Can it be the week after that?
Fantastic. We'll have, I was thinking of using the in 2025. List the matter on 8th of January 2025. The affidavit will be filed in the
44.
Same. It is same order.
They can come up on the same day.
It is fixed for you 8th of January. No? Affidavit filed?
No.
Yes, they have filed. Respondent number 1. They may not have given it to you.
Previously filed, but respondent number 2 to 6 took time. But
Who is respondent number 2 to 3?
Failed to.
Okay. Mr. K. Gogoi appearing on behalf of the Respondent numbers. Who? For finance? For? Respondent number 1 has filed. You are paying for? Okay, appearing on behalf of the district administration. Appearing on behalf of the respondent number 3 to 5, 3, 4, and 5. All are different persons. So how do you file? Everybody has to file differently. 3 and 5 will be one, 4 will be different. How? How can a superintendent of police and deputy commissioner both intermingle in this manner? Anyway, appearing on behalf of the respondent number 3, 4, and 5 submits that the affidavit is ready and would be filed. Who's to list this matter again on 22nd of November. In the meantime, the affidavit will be filed on behalf of the same respondent.
Item 63.
Judicial Lordship, where this honorable court's order 27/8/2024. Thereafter, my lord, the respondent number 4 filed the affidavit in opposition.
You have filed your reply?
Yes, my lord.
Now what happens?
My partial land is, my lord, in location to ask for is situated. My prayer, my lord, the compensation may be pay for compensation.
Who is to pay you the compensation? Your land has been taken away.
Taken away, but compensation not given.
Not a single penny.
But 20.
And as per government, have you filed affidavit? As per you, have you? Oh, yes, yes. Then what happened?
Now, my lord, my understanding is affidavit is reply. They say this is the one that the 30th case, my lord, wrongly, my lord, don't have them on a top level. So this name, the immediately is.
Hello.
They, this document they will brought my lord by the signed, my lord, in the decision, there is no any documents taken.
Do you want to take instruction? Mr. J. Hendrick, appearing on behalf of the respondent state, submits that in view of the reply filed by the petitioner. Reply, no?
Yes.
He would like to take certain instructions. So list this matter again on how much? 27th of November. Okay. 4th of December. 4th of December.
64.
Lordship, in this matter, respondent number 2 has filed an affidavit, Lordship. We'd like to file.
Oh, they
Lordship.
receive money.
Not all, Lordship. Not all.
One, this that three petitioner, the three petitioner, one is the compensation amount, and 2, 4, and 7, 2, 4, and 7 is the compensation. 3, 4, 5 and is there, and the 5 is one.
Okay.
Respondent number 3 has stated.
You,
also that-
Mr. Counsel, you were fighting all along because of petitioner number 1. Now your main, what do you call in a ship you have a particular thing, no, the cradle. The cradle is no longer there.
Respondent number, petition number 3 has assured me that he's going to contest the case here, Lordship.
That's
No one else will stand alone, Lordship.
we do it next year.
Lordship, 2 weeks time to file a affidavit, Lordship. 2 weeks time to file a reply affidavit.
I'm giving you.
Lordship.
Discuss matter again on 10th of January 2024. In the meantime, the petitioner would be at liberty to file the reply.
Orders item 46.
Yes, orders which is essential necessary.
The demolition matter, my lord.
Which matter?
66. 66.
60?
66, my lord, supplement.
Okay. And anybody else?
46, Lordship.
46. What is that?
Lordship, here, the son of the petitioner, while he was an UTP, he died. He died in a unnatural death inside the jail premises. And there in the postmortem report, there was a direction to send the viscera for forensic science examination. And Lordship has directed to make an inquiry by.
Oh, by the district judge. Yes, they 46. I remember. Long time, 6 months back.
Yes, my lord, that order was passed on 23/1/2024.
Then what has happened?
Then, Lordship, the inquiry report says, my lord.
Has the inquiry report submitted?
Yes, submitted.
Now
And
what does it
thereafter,
say?
my lord, I have filed one, my lord, affidavit, my lord. But that affidavit is not before your lordship.
Now what is the inquiry report say?
Inquiry report says, my lord, lordship has framed two reference, my lord. 2 points, my lord. First, whether there was any negligence on the part of the jail authorities of the district jail Golaghat in providing the adequate medical facilities to the son of the petitioner who is led to the death of the petitioner's son. That was one first. And second one was whether the death of the petitioner's son had occurred due to cardiomyopathy along with coronary artery rupture or for any other cause.
So, what remains?
But my lordship,
And now, otherwise you should have gone to the civil court. After this report, we can't do anything. You want to cross-examine these people. Then what do you want?
But my lord, I just bring.
I am not going, you see, we have got a judicial inquiry done, got an inquiry report done in respect to this incident which happened long time back. When did it happen?
But it is the, my lord, from the inquiry report itself, it is
2002.
very much, my lord, clear, my lord. My lord, even, my lord, the viscera was not for forensic examination, my lord.
What?
The viscera, my lord, that was not sent by the concerned IO for
Understood.
forensic examination, my lord.
What? Yes, I remember there was a question in the postmortem, it was written that that viscera should be sent to the forensic for the purpose of ascertaining as to whether there is a case of poisoning.
Yes.
I remember that.
Yeah.
But the fact that there has been an inquiry being made, one has to, either you have to complete with this or you have to go to the civil court. But the civil court is going to have you no way. Now this has to end here.
But my lord.
You see, we can only, no, Mr. Counsel, the question is we got it done. This was an order. You see, first of all, it was a very lately this court have taken up. The matter could have been taken up early, taking into account that this is a case of a custodial debt, which should have been taken earlier. But be that as it may, we have taken up, when I took it up, it was too late, for which I directed the district judge to look into it. The district judge has taken an opinion. I am not going to sit over those factual findings.
But my lord, this reference, my lord, whether he was died for any other, my lord, it is admittedly, my lord, from the report itself it clears, my lord, that, my lord, the viscera was not for forensic examination. So, my lord, as because my son was a UTP.
How can the viscera now be taken into forensic examination? Tell me, it was not sent then.
It was not sent.
Yes,
That's
now
why-
it is
that's
not
why-
sent. Can it there be a question, therefore,
Yes.
you say that there was a case of poisoning now?
My lord, but, my lord, from the cumulative effect of all these, my lord, omissions on the part of police and the jail
Mr.
authorities.
Counsel, there has to be a closure. Everything needs a closure. See, we have got it done. This has been done by the Golaghat district judge. Yeah?
District Judge Golaghat.
He's a
But, my lord, please, my lord, my affidavit may come into record, my lord, so that, my lord, I just point out, my lord, because, my lord, our High Court has, in spite of, my lord, different opinion in the, my lord, inquiry report, High Court has directed compensation, High Court has directed, my lord, investigation, my lord.
which court? Where?
This High Court.
Where?
Followed by, my lord, judgment of our division bench, my lord.
Where? So you have therefore to, the best option is there, na? Let me dismiss it. Go to the division bench. One. Or now those two judges are not there. So now these two present judges, you have to settle with it.
Kindly, my lord,
Nothing doing.
because my lord, the report is not conclusive, my lord. They ought to have, my lord, reflected.
I am not going to look into this thing.
Because, my lord,
This
the
is a
reference-
fact-finding inquiry which we have done. They did not found out this thing. This is okay. Something has to happen.
Sort it, my lord. I try to satisfy lordship. My lord. Because, my lord, the 2006, my lord, 3 SCC, my lord. That says, my lord, when the, my lord, High Court has directed an inquiry to be made in a particular manner, it should be done in a particular manner.
So who said? Supreme Court?
Yes.
Fantastic. From there again, you have another avenue to go to Supreme Court. Go there. Nothing doing here. Because of the fact that the viscera was not done, can it say it to be a case of negligence?
My lord, but my lord, it may be a case of poisoning, my lord. Well, at least, my lord, I ought to have get some definite concrete result how my son died, my lord. My lord, from the
This is the
cumulative
opinion.
effect of all
This
my
is the
lord, that
opinion.
has-
You want, therefore, I'm saying, na. So the question, therefore, is, did you file an FIR?
My lord,
Did you file an FIR?
no, my lord, the EV case was registered. I
Did
have
you
not
file a
filed-
complaint?
I have not filed anything.
Why didn't you file a complaint? You could have filed a complaint, went up to the Supreme Court and got a judgment there.
My lord, in this case, my lord, I pray for an judicial inquiry as well as.
Your
my lord,
judicial inquiry
and, my
done.
lord- My lord,
No, no more.
see, my lord, it is from the. inquiry
Incident
that
happened in
we-
2012. You approached this
But
court
my
in
lord,
2016.
My lord, one more thing, my lord. The person, my lord, it says, my lord, from the inquiry report says, my lord, after taking dinner, this is reported to the co-prisoners that he suffered some ailment. And then, my lord, the co-prisoner reported the same to the jail authorities. And specifically in their affidavit also.
This the
specific
matter
names have been-
which are taking into account the reports which have been duly submitted
No co-prisoner was
and
examined.
some affidavits being filed by the petitioner, which is not yet come on record. List this matter again on 23rd of January 2025. For hearing. 21st of January. Yes.
Item 66, my lord.
Hmm.
My lord, here is a case, my lord, at the instance of my rivalry party, DMC has issued a notice that we have put under challenge, and that was stayed by this honorable court. After my during pendency of this stay order, my lord, another notice we have received. Lordship state, we kindly see my eye, page number 17.
Others may go if you have no urgency out here.
But because the final notice has been issued for demolition.
Not for you, others. I'm
Okay.
saying. Others are waiting out.
Other,
Oh, Guwahati Municipal Corporation.
my lord.
Interesting.
They're creating problem at the instance of my rivalry party, my lord.
Huh?
At the instance of my rivalry party, GMC is creating problem. But Lordship, kindly see, initially notice was issued to us. My lord, that we have put under challenge before this honorable court. This honorable court stayed the further proceeding. Now, during pendency of that stay, my lord, another notice of demolition we have received. The main condition that we don't have the NOC, my lord, building permission. But my lord, the GMC itself has issued the my lord, NOC in our favor, my lord. Lordship, kindly see.
29/10/2029. Who is paying for the GMC? Anyways, we'll take it up tomorrow. We'll hand it with the GMC. GMC is doing it for you. For others, the GMC doesn't do. There, tomorrow I'm taking up another matter. We'll have it. Let's this matter tomorrow. Yes, GMC.
Yeah,
Which state? Yes. No. Mr. Vora, today in the morning I got hold of one case and I am really disappointed in me earlier. Sometimes thinking about that the GMC does good work and seriously he exercises his jurisdiction. Cases where Assam type house being constructed without permission, I have not interfered. But today I could find out that permission is given for G+2. The GMC, he makes the construction to G+7.
My God.
GMC does not do anything. And after 8 years, when somebody else files a writ petition after 8 years, the GMC has not filed the affidavit, takes the year, we have lost the file. So under such circumstances, when 5 stories can be made in an area which is hugely populated, what heavens will fall if you
5 lesser
stay.
lane, my lord. Only 5 lesser lane, small construction. Old person, my lord.
These are cases to be
They have to
no,
put in
no.
jail, my lord.
These cases are to be stayed, and GMC's power under 337 should be stricken off because of the misuse
Misuse,
being
it is
made
same
by them.
case.
No, when it is required, you don't do it. You don't do it when it is required. It is very strange. I'm telling you. I'm very disappointed today at the actions of the GMC. I'm nothing against the council, but I'm saying it. Means it is really sad that you have been given a power. I've been always very strict on the question of building there, taking into account that the Supreme Court is doing it. But if I take it to certain matters out there, the GMC is not bothered. They come to the standard out, they take a stand before this court to that effect. They look here, they have made 7 stories, it's okay. But we have lost the file. And the file got burned. So now we can't do anything. Right? When everybody admits that I have G+2.
That will come up with that. One day the bulldozer will come, my lord.
No, it won't.
One day, my lord.
So let the one day come for them also one day. So what?
My lord, stay order is in operation. Despite of that, my lord, notice has been issued. My lord, can you see their courage, my lord? They are even not carrying the order of this.
No, don't do anything.
My lord, what document they are seeking, my lord? They just stay order, my lord.Espite of that, my lord, they have issued the final notice.
Where is the notice? Where is the notice? Impugn notice 2910. 2910.
Yes, my lord. And permission is there, my lord. Next page is permission. What letter on 710, my lord?
What he says that a building was constructed and we already did the building. He
What?
takes out a permission letter. There is already a building, sometime house.
Mr. Counselor, that is why I'm saying G+2. They construct and you see the audacity of the GMC. Tomorrow I'm having I have asked the commissioner to appear in person. G+2, he makes it to G+7, and by paying 2,30,000, GMC say that we have compounded it. No, wait. Floors cannot be extended, it is non-compoundable, they have compounded it. And when the civil court asks for the document, they say, oh, we lost it in the fire. Lose this also in the fire. Lose.
Is it something different?
No, it is not. Every case GMC has to be looked into in this manner. This is a very serious
please,
thing
Madam
which you have
Secretary.
done. I'm very disappointed, Mr. Bora. Kindly tell your GMC authority, it's very disappointing what they are doing.
Madam.
That day, there was another case where the GMC on one fine day takes over. At night, 12:30, they go and take over a particular property of somebody. Yes, why? The additional secretary gives us a call.
Here the councillor role is there also.
No.
Same case.
If these are the things, if the GMC is resorting to hooliganism, why the GDD department is not taking any action?
There was a text. What notice was given? What notice will give some sort of reply. And he, then the.
2910 is a show cause notice. Then he gives a reply on 411. Then
But he takes out the permission on 7th.
but he has a permission.
Yes, my lord.
Why did you give a permission? Why did you give a permission? Are you going to now think that, oh, we have given you a permission, but earlier construction which you have made, you demolished, now you again build it.
For the permission now.
So you want to demolish it and then he will build it.
My lord,
When the act, my lord, there was no NOC, permission was not there.
A very important constitutional question of law has arisen that whether it is necessary for the GMC to first demolish it at the cost of the petitioner so that the petitioner who has already a permission now can construct it at the cost of the petitioner.
Why they have made the provision of regulation, my lord?
The building was constructed.
My lord, they don't have any say, my lord, stay order is in operation, despite of that. my lord,
Anyways,
action is-
We'll have it day after. And
13th,
no,
my lord.
don't do anything. I'm passing an order, don't do anything. The instant application has been filed by the petitioner. Petitioner, who is the applicant in the, by the writ petitioner. Alleging, apprehending that in view of the notice issued on 29/10/2024, the respondent GMC authorities would demolish the building of the petitioners in spite of the fact that the petitioner have now the permission,
And stay order is also there.
and there is also an existence of a stay order. Full stop. On the other hand, Mr. Esbora submits that the cause of action in respect of which the stay order was passed is different from, in view of the fact that subsequent to the stay order, a fresh notice has been issued. Isn't it?
But then it has been sent to the, by the.
No, therefore I'm saying fresh cause of action has arisen for which you have issued this notice. Full stop. Full stop. He, however, submits that he would obtain necessary instructions in that regard and requires 2 days in that regard, 2 days time, and requires for 2 days, and requires 2 days. Full stop. Accordingly, this matter again on 11th, top of the list.
Yes.
11. Not an 11, but it's not 13.
13th November 2024, on which that Mr. Esbora shall obtain the necessary instructions. It is also seen that as of now, there is no order being passed by the GMC, by the commissioner in terms with section 337 of the Act of 1971. Accordingly, this court taking into account, according this court as presently being session of the matter, directs the Commissioner GMC not to take further steps as regards in pursuance to, not to take any steps for demolition in pursuance to the notice dated 29/10/2024 till the next.
My lord, in main case stage also that record continue.
What is that state?
My lord,
We'll look into it. This
My-
year you have
my-
got, where your building is protected, what
My-
do you,
I don't know, my lord, what they will do. Even
but
they are
it's
not
a,
getting
it's a
stay
very
order.
sad thing. Tomorrow let us hear why the GMC is doing. No, therefore I said, no, we'll
The
fix
big
it.
case for put them in jail, my lord. If I suppose he insists that much of thing, that notice contain the last notice also, my lord, the final notice.
Mr.
not
Bora,
playing
Mr.
fire, man.
Samaria is aware. He was the GMC council.
Going on, madam. You can get a document.
I know he's playing with fire, my lord.
Correct picture will come up with what is the circuit violation. Whether there is the NOC. And he challenges it that for the ground of section 30.
You get your instructions, Mr. Bora, but just find out anything you want, I can even take it up on Friday. But the thing is, either Friday or today, 13th at the top of the list, huh?
Give you, Lordship, item number 60, can it come up on 11th, your Lordship?
Why, what is that?
Your Lordship, it was related to your Lordship has passed an order.
Oh, that one,
Yes, Your
not
Lordship.
filing the area
Just
within
a
time.
minute. Yes, your Lordship.
Have you informed them? Have you given a
Yes, your
copy to
Lordship.
the
Yes,
other
sir.
side?
Yes, sir. I've given.
And item number 60 to be listed again on 14th November at 2 p.m.
Can it be on 11th, your Lordship?
Mr. Counsel, this will come up again for orders and way down the list. So I'm putting it on a Thursday so that 2 p.m. I can pass the order in his presence. Then the other side will be there. That is why I'm giving you. But you want again and have it,
No,
because
your-
515, I can't pass an order.
Your lordship.